Так, нас слышно? Да, должно быть слышно. Добрый день, уважаемый Александр Николаевич. Добрый день, уважаемые эксперты, которые к нам подключились по Zoom. И добрый день, уважаемые участники. От команды...
Да, вас слышно.
Видимо... Добрый день, уважаемый Александр Николаевич. Добрый день, уважаемый...
Вас не слышно.
Да, просим прощения за технические неполадки. Еще раз добрый день, уважаемый Александр Николаевич, уважаемые участники. От команды организаторов позвольте искренне поприветствовать вас на международной научной студенческой конференции «Актуальные проблемы международного права», посвященной 30-летию Московского журнала «Международное право». Международное право – это основа международных отношений, эффективный механизм защиты государств, интересов государств на международной арене. Кроме того, международное право создает механизмы защиты прав человека, имеет значение для юридических лиц и в конечном счете отражается на жизни каждого из нас. Хотелось бы выразить уверенность в том, что участники нашей конференции через несколько десятков лет будут делать свой вклад в развитие международного права, работая в международных организациях, в внешнеполитических ведомствах своих государств, правительствах, а может быть и развивая доктрину международного права. Уверены, что те знания и опыт, которыми вы сегодня будете друг с другом обмениваться в ходе работы 3 секций конференции: право международной безопасности и защита прав человека, международное экономическое право, основы недропользования, сотрудничества в сфере энергетики и охраны окружающей среды и международное воздушное космическое право. Уверены, что будут полезными для всех ее участников эти обсуждения. И хотелось бы отдельно отметить, что при реализации данного проекта нашему студенческому сообществу МГИМО, юридическому студенческому сообществу удалось выйти на качественно новый уровень организации проведения научных мероприятий. Конференция объединила более 100 участников от Владивостока до восточного побережья Соединенных Штатов. Мы получили заявки из вузов 10 государств: Армения, Беларусь, Казахстан, Китай, Киргизия, Сербия, США, Таджикистан, Швейцария и, конечно, большого количества российских вузов: это МГУ, МГУА, РУДН, Высшая школа экономики и другие. Я, как магистрант, осознаю всю студенческую потребность в таких мероприятиях и рад приложить, что называется, руку к созданию такой возможности. И от всего студенческого сообщества мы бы хотели выразить свои слова благодарности руководству нашего университета, которое вот уже на протяжении 3 лет всячески поддерживает все инициативы юридического клуба, оказывая любое содействие на всех этапах подготовки, проведения мероприятий. И, разумеется, кафедру международного права МГИМО, которая с энтузиазмом поддержала нашу идею проведения международной студенческой научной конференции, обеспечив и экспертное сопровождение работы секции. Юридический клуб за 3 года своего существования стал одним из самых быстро развивающихся студенческих объединений в университете. Студенты стараются уделять внимание всем отраслям права. И очень символично, что первое международное мероприятие юридического клуба посвящено именно международному праву. Сейчас хотелось бы предоставить слово научному руководителю конференции, заведующему кафедрой международного права МГИМО и главному редактору Московского журнала международного права, профессору Александру Николаевичу Валикжанину.
Спасибо, Алексей. Рад приветствовать тех отважных участников конференции, которые собрались здесь в очном формате. Приветствую, конечно, тех, кто, невзирая на технические трудности, рискнул участвовать в дистанционном формате в нашей конференции. Действительно, то, что Московскому журналу международного права 30 лет, Это знаменательное событие. И очень хорошо, что именно студенческий форум открывает вот эти юбилейные мероприятия. Это в следующем году у нас будет международная дискуссия главных редакторов по международному праву журналов, в котором уже подтвердили свое участие практически все ведущие мировые журналы по международному праву. Будет международная научно-практическая конференция, но это будет. А вы, пионеры, вы открыли эти мероприятия. И, конечно, в этом плане кафедра международного права, редколлегия Московского журнала международного права вас приветствует и желает успеха. Я хотел бы подчеркнуть, что, конечно, сегодня статьи в Московском журнале международного права отражают, может быть, наиболее злободневные вопросы юридического характера международной повестки дня. Вот возьмите последний, скажем, номер журнала, который сейчас уже издан, второй номер, и там статья директора Женевского центра по международной безопасности господина Вестнера. Вы видите, что у нас статьи на английском языке и на русском языке публикуются. Ведь это действительно зарисовка очень сложных проблем международного права. Как остановить гонку вооружений сегодня в космическом пространстве? И естественно, что для студента читать с карандашиком вот эту статью, пытаться понять юридическую аргументацию автора, который практик, который авторитетный специалист в области международных отношений, непросто. Учебник открыть проще. Там все ясно, доступно, понятно. Здесь сложно, иногда непонятно. Но то, что вы приобщаетесь к теории международного права уже на студенческой скамье, это, конечно, здорово. Я хотел бы вот еще раз подчеркнуть, что когда мы говорим о праве, мы вспоминаем, если хотите, истоки. Jus est ars boni et equa. Право есть искусство добра и справедливости. Искусство создается разными людьми, разными художниками. Возьмите, например, договор между Российской империей и договоры между Великобританией, 17 век. Вы уж американские наши студенты, не обижайтесь, еще Соединенных Штатов не было в 17 веке, поэтому я привел этот пример. Эти договоры разные, но тем не менее Российская империя и Великобритания договорились о статусе границ в Арктике. Это первый международный договор по Арктике, договор 825 года. Он и сегодня является частью международного права. Так и в искусстве. Вы посмотрите, 3 грации Боттичелли. Это фрагмент известной картины «Весна». И 3 грации Рубенса. Разные творения, но общая тема. И когда мы говорим о международно-правовой доктрине, ее действительно творят разные художники. Скажем прямо. Вы откройте Московский журнал международного права и, допустим, American Journal of International Law, European Journal of International Law, Droit International Public и так далее. Вы видите, что эти журналы создаются разными толкователями международного права. Но тем не менее, есть общее. Все они нацелены на корректное понимание международного права. Все они с точки зрения статута Международного суда ООН, статья 38 известна, являются международно-правовыми доктринами, то есть вспомогательным средством для определения правовых норм. Я это к чему говорю? К тому, что, конечно, вот приобщение ваше к научно-правовой деятельности – это очень значимо. И, конечно же, я понимаю, что большинство из выпускников МГИМО, большинство из выпускников других вузов идут не в теорию, не в науку, идут в практику. Но хочу заверить, что даже работая в практике, вот эти навыки глубокой аналитики, они вам точно помогут. Поэтому, завершая, я хотел бы еще раз сказать, важно, чтобы в ходе вот этих нескольких дней, когда вы будете обсуждать ваше видение той или иной проблемы международного права, важно, чтобы вы вслушивались в доводы друг друга. Вы представляете разные международно-правовые школы и внутри России, и за рубежом, и уметь понять, уметь выслушать – это очень значимо. Это уже само по себе поможет для будущего юриста-международника решать будущие сложные проблемы на практике. Успехов вам и самые добрые пожелания. И, конечно же, традиционно доброго здоровья.
Спасибо большое, Александр Николаевич. Уважаемые участники, в завершении нашего короткого открытия конференции хотелось бы напомнить вам о формате работы. Сегодня после небольшого перерыва мы начнем работу секции «Право международной безопасности и международная защита прав человека», которая пройдет на английском языке и продолжится завтра, 16 декабря. 17-18 декабря пройдет работа второй секции «Международное экономическое право, основы недропользования и сотрудничества в сфере энергетики и охраны окружающей среды». И, наконец, 18-19 декабря пройдет третья секция «Международное воздушное и космическое право». Обращаю ваше внимание, что вне зависимости от формата вашего участия, очный или дистанционный, мы ожидаем вашего присутствия в оба дня работы соответствующей секции, доклад в которой вы представляете. И, кроме того, у вас, конечно же, есть возможность подключиться к работе других секций в соответствующие дни их проведения. Программы вам были высланы, поэтому будем вас очень ждать и на других секциях. Все технические моменты уже обсудим непосредственно во время работы секций. Единственная просьба, я надеюсь, что сейчас ее услышат все участники всех секций, которые подключились на открытие, просили бы вас направить ваши презентации, если вы вдруг этого еще не сделали и планируете демонстрировать презентации во время своего выступления в работе секции, направить их заранее. Вот. В целом, всем еще раз спасибо большое, кто подключился к нам на открытие. Сейчас уходим на небольшой перерыв и в 15 часов начинаем работу первой секции. 15:00. Good afternoon, dear participants. My name is Alexey Starikov. I'm the head of MGIMO University Law Club. We are now live on YouTube, and we are expecting a day of very productive discussion. I would like to express my appreciation to all of you who joined us today, those who care, those who are interested in the development of international law, its current problems. We're happy to welcome participants from various Russian universities and, of course, our foreign colleagues. The pandemic has forced us to actively use technological advances, and we see that it benefits all of us. I hope that these meetings will become traditional. The world is definitely in a process of big transformation, changing before our eyes. All threats such as arms race, weapons of mass destruction, ethnic conflicts have not been eliminated yet. And at the same time, more and more threats are added to them. Cross-border terrorism, cybercrime, information wars, climate change, and pandemics, of course. It is international law that constitutes the mechanism by which these problems can be solved. That is why the international scientific discussion of students who will take part in the development of international law in the future is essential. There will be about 20 speakers today. The diversity of papers submitted is truly surprising. So we are aiming to cover a huge range of topics. I sincerely hope you will enjoy the next 2 days of debate and networking. And now it's my honor to introduce our experts. We are fortunate to have the support of Doctor of Law, Professor, the head of MGIMO International Law Department, Editor-in-Chief of the Moscow Journal of International Law, and Scientific Advisor of the conference, Alexander Nikolaevich Velekzhanin. And we are also expecting Professor of Practice in Science Diplomacy at the Fletcher School of Law and Diplomacy at Tufts University, Paul Berkman.
He will join later on, probably
Yeah,
in 2 hours.
Yeah, since
like
Professor
that.
Berkman is pretty far from us and in a different time zone, he will join us in Zoom a little later. And now it's my privilege to give the floor to Alexander Nikolaevich. Alexander Nikolaevich.
Thank you, Alexey. Once again, I wouldn't take much time. I understand that lots of presentations are already submitted, and I understand that everybody is ready already to speak on the very important topics which are outlined. And just probably a few remarks relating to our specific session. I would like to underline that today the risks of World War III seem to be increasing. It's not my opinion. It's opinion which is reflected in a number of articles published in Moscow Journal of International Law, in American Journal of International Law, in European Journal of International Law, and so on. That is a reality. So our section, which is considering issues, legal issues of international security, seem to be probably the most important for international relations today. And just one citation from the Moscow Journal of International Law. This year, it is 75th anniversary of the great victory of the Allies, Britain, the Soviet Union, and the United States of America over Nazi Germany. The most important legal result of this victory has become the Charter of the United Nations, the Universal Treaty initiated by the Soviet Union, Great Britain, and the United States of America, later by France and China, aiming to save succeeding generations from the new World War by establishing United Nations mechanism to maintain international peace and global security. I think that when you will be discussing your topics, which are of course very different, you should bear in mind the common interests of states. And the common interests of states today is not only pandemic, of course it's evident right now, but also, of course, the aim which is already reflected in the United Nations Charter. And as you perfectly know, the United Nations Charter is the main source of the modern international law. And according to Article 103, the provisions of the Charter have a sort of superiority over provisions of any other international treaties. So, once again, I would like to express my gratitude for organizing such an international conference between students, and I wish you success.
Thank you very much, Alexander Nikolaevich. Dear participants, before we begin with our first speaker, I would like to clarify some technical issues. First of all, our time limit. So since we have a lot to share today, we set a strict time limit, 7 minutes for presentation of the report and 3 minutes to answer questions. 1 minute before the end of your speech, we'll let you know about it. So participants in Zoom can express their desire for the speech or to ask questions. They can do this by using the raise hand button in Zoom. I also would like to remind that screen demonstration can be used only by the moderator during the conference. Therefore, please send your presentations to our email address if you haven't done so. Also note that participants in the conference room have to turn on their microphones so that colleagues in Zoom can hear us. So our first speaker today is first-year student in International Relations, Geneva School of Diplomacy and International Relations, Pank David Andrei. In his report, he'll try to answer the question, what legal methods could have been used to prevent the World War III? Please, David, the floor is yours.
Thank you very much, Alexei. Before I start, I would like to thank MGIMO University and at the same time Geneva School of Diplomacy for allowing us to speak in such a beautiful crowd and in such an honorable public. And now I would like to try to find together with you some legal ways of preventing the Third World War. If you are to think about the concept of the Third World War, many people would claim that the possibility of another major conflict is almost impossible. However, if we take a closer look at today's conflicts and at the tensions between certain nations, all of us would certainly agree that the probability of another global war is increasing day by day. Although the escalation of tensions are increasing constantly, it is not too late to stop them. This report aims to analyze the legal possibilities through which another catastrophic global conflict might be prevented. First, let's discuss about the current situation. If you are to analyze the current situation of the international stage, we would definitely be surprised by the decreasing level of international security across the globe. We would only have to look at a few states such as Afghanistan, Syria, or Ukraine to realize that conflicts might erupt faster than expected. Although the conflicts are significantly smaller than those that happened a century ago, let us not forget that one small conflict can lead to a full-scale global war. Many argue that the creation of international organizations such as the United Nations, military alliances such as the North Atlantic Treaty Organization, or international institutions such as the European Parliament represent a solid barrier against the enormous wave of possible conflicts. But let us remember the dark past of the 20th century. Back then, organizations such as the League of Nations played a similar role as the international bodies we have today, and yet the Second World War still took place. But why? The answer is simple. The previous as well as the current international organizations are filled with weak points such as not treating all members equally, allowing superpowers to extend their influence over other states, or not responding to the threat of a future conflict in time. It is really important that the most intergovernmental bodies of the international community go through a thorough process of reforms in order to respond to all kinds of threats effectively and respect and protect each and every member from possible abuses which might lead to wars. At the same time, one of the leading factors causing tensions all around the globe is solemnly represented by the interest and behavior of the global superpowers. Let us look at two examples. In the previous years, many US-led NATO exercises took place in the vicinity of the Russian border. The exercises which took place in the Baltic Sea, such as the annual Baltops drills, not only raised tensions between the Russian Federation and NATO, but were also seen as a provocative behavior of the United States of America by the Russian leadership. Another significant example is the Russian occupation of the Crimean Peninsula, which took place in 2014. The annexation not only increased the tensions between the Russian Federation and the West, but also sparked a conflict between Ukraine and pro-Russian separatist forces. As the possible candidate of the North Atlantic Treaty Organization, the Ukrainian war was not only seen as a breach of sovereignty, but also as a Russian campaign towards continuous expansion by certain figures. The above-mentioned examples not only emphasize the need for important reforms within international bodies, but also the need of preventing the interests of certain superpowers to turn entire countries into battlefields. What to do? With the current situation of the international stage summarized, it is time to move on to discussing effective and proper solutions which might help turn the tide towards a more peaceful world. On the one hand, immediate reforms within international organizations, alliances, and institutions are needed. Organizations such as the United Nations must maintain an iron fist when it comes to respecting the international law, not only on the member states, but within the organization itself. The abuses committed by UN peacekeeping forces in various African countries, such as the Central African Republic and the Democratic Republic of the Congo, are just a few examples from a multitude of crimes which were carried out under the so-called protection of the organization. Another example which proves the lack of measures within the UN is the failure to prevent the conflicts in Syria and Yemen, which have resulted in thousands of casualties. On the other hand, superpowers must be held accountable for their actions in accordance with the international law. A clear example of the constant abuse of superpowers are the recent protests in Hong Kong and the previous invasion of Iraq in 2003. Due to the fact that certain international bodies have allocated exceptional powers to major states such as the USA or China, these countries get away with their abuses most of the time. It is of utmost importance that the powers of these countries are significantly reduced and that they are held accountable for their actions in accordance with the law. If we are to take these measures, the risk of a full-scale global war will strongly decrease, and the international community will not only benefit from a safe environment, but also from a multitude of opportunities resulting from the tight international cooperation. Thank you.
Thank you very much, David. Thank you for your interesting report. Dear participants, dear Alexander Nikolaevich, if you have any questions or comments for David.
If there are no questions from students, will you permit me a couple of questions?
Sure.
Thank you. You mentioned in your report about the occupation of Crimea by Russia. My question is, first, have you read the book of the Ukrainian Prime Minister Nikolai Azarov on the events of these 2012-2014, and also the events relating to the US ambassador instructing leaders of the opposition how to change the constitutionally elected President Yanukovych by these putschists? Have you read this book?
Unfortunately, I didn't manage to read it.
My advice is, whenever you are speaking about such complicated things, you're supposed to read more, because this book is written not by journalists. It is written by the Ukrainian Prime Minister, Nikolai Azarov, with documents, references, and evidences. And by the way, the book of US President Biden now, at that time, Vice President of the United States, just is a confirmation of the facts which are reflected in the book of the Ukrainian Prime Minister Nikolai Azarov. It's just my advice to be more professional. Before you say something, you're supposed to read more. Thank you.
Thank you very much, Alexander Nikolaevich. Andrei, do you have any comments?
No, not really. I would kindly like to thank the professor for giving me this advice. And at the same time, I would like just to emphasize that I mentioned this controversy on the international stage just to explain that tensions can arise pretty quickly. Thank you.
Thank you very much again for the interesting report. If our participants in Zoom don't have any more questions, we'll jump to another report. Kuchba Kueza, International Law, fourth-year student, МГИМО University, the relevance of the just war theory in the 21st century.
Thank you very much. Well, first of all, I thank you, the organizers, for giving us this opportunity to present our reports. And I think I shall start. Well, when speaking in general about the moral reality of armed conflicts, public international law considers them subsequently from two aspects. On the one hand, there are the plausible justifications that the states must have when intending to wage war. This is what is called jus ad bellum, or the justice of war. On the other hand, there are the rules that must be complied with once a war already takes place. This is what is called jus in bello, or the justice in war. And the combination of these two sets of principles constitutes a rather old theory known as the just war theory. And although the roots of this just war theory grow as deep as the Code of Hammurabi, the Indian Mahabharata, the laws of Manu, and many other sources, many other ancient sources, Saint Augustine is usually considered to be the first to introduce these theories, these principles as a doctrine that stems from the Catholic moral theology. And Saint Augustine referred to the Bible and regarded some wars as necessary to amend an evil. After Saint Augustine, there was Sir Thomas Aquinas, who created his version. He created 3 criteria for a just war. So the war needed to be waged by a legitimate authority. It needed to have a just cause and have the right intentions. So the aim, the initial aim of the just war theory was and has always been to provide a guide to the right way for states to act in potential conflict situations. And so to speak, a just war is permissible because it is a lesser evil. And for many years, as we can see, the laws of warfare arose from custom and tradition. The resort to war and the conduct of war, jus ad bellum and jus in bello, were determined by religious and moral considerations rather than notions of international law. This situation changed rather dramatically in the 20th century when the decision was made to codify all these sets of rules. However, unfortunately, these actions were not able to create a much safer world due to the challenges that the public international law is facing and has always been facing due to the current events. And one of the first such challenges, named, for example, by Knut Ibsen in his main work was the asymmetries of warfare. Despite international humanitarian law assuming the participation in a conflict of two parties more or less equal in different regards, there can be seen strong inequalities nowadays. More precisely, Knut Ibsen addresses mostly the problems of the forms of asymmetry, such as technological, doctrinal, or legal. But what seems more outstanding and relatively newer and more powerful is the political asymmetry. There are some cases in the 21st century that highlight a clear failure of the UN Security Council to act in line with just war principles set forth in the UN Charter. And for example, in one of the works concerning the public international law and the challenges that the public international law is facing, Delahunty and Yu note that the most conspicuous case is surely that of Rwanda, where the Security Council unfortunately failed to authorize a timely military intervention that could have prevented a mass genocide. Similarly, the Council's refusal to authorize the NATO-led intervention in Kosovo in 1999 is another obvious case. And such behavior was dictated by the political standing of the UN members. Another challenge faced by the just war theory is the fact that the practices of the world community do not correspond to the existing rules. One of the important principles of international humanitarian law is the distinction between civilian population and military targets. However, the so-called civilized countries prove the contrary and justify their actions by giving it a name, collateral damage. Thus, for example, air raids are carried out from great heights to avoid adversary defense, and the result is less effective precision and unintended damage. Furthermore, the most alarming of all is the fact that the just war theory overshadows the prohibition of war. With the existence of legalized rules of the game, states have a tendency to neglect jus contra bellum and alternative methods of dispute resolution. So the just war theory, as one may see, is the result of the long history of humanity and ethical philosophy. First, it appeared as a natural response to the challenges faced by the humanity at the time. But in the modern world, some changes must be made. Rules should encourage the use of proportional force where the benefits outweigh the costs. Thank you very much.
Thank you, Kueza, for your interesting report. Would listeners or conference participants have any questions to our speaker? Yeah, just turn on your microphone.
Yeah, thank you very much for your research. But as far as I understand, you claim that, well, some changes should be made. But can we please hear maybe some proposals of yours? I mean, what changes to your mind can be made?
Well, first of all, we need to consider the fact that once the global community has codified all these rules, they have become kind of too static. What I mean by that is that the world is still changing since the 20th century as well. And that's why I think that theories like this and principles like this, they must not be too static. They must be made more open to changes, and not just changes by the states when a conflict already takes place, but in general, there must be held some maybe conferences that always discuss the changes in these principles so that they become more up-to-date, more relevant for the modern world, for the modern conflicts.
Thank you. Any more questions?
there is one question in the Zoom chat.
Yeah, could you read it out, please?
Yes, of course.
Question from
No. Our moderator will read it out so that you can answer.
Yes. Does Libya represent an example of why just war isn't always just? Does that incident take us back a step in R2P and just war?
Excuse me, could you explain what R2P is?
Ahmad, could you explain, please, what do you mean R2P?
Ahmad, could you turn on your microphone and ask a question?
Right to protect. Okay,
I just mean the right to protect. So does incidents like Libya, where you have originally evidence that seems to suggest that you have a humanitarian issue at hand that needs to be assessed, and then the P5, the Security Council votes to allow airstrikes to occur, and then it turns out to be much more of a debacle, much more of a negative in the long term. Does that represent a black marker or trouble going into the future for just war?
Thank you very much for your question. Well, actually, in this case, I have read a book by Michael Walzer, where he was talking about the just and unjust wars. And I think that Libya also was discussed in the book. But if speaking in general terms, I must say that actually I did not mention it in my report, but another challenge that I see in this situation is the challenge concerning the legalized intervention. So I think that in this case, although I have said that the principles must be discussed all the time, I don't think that they must be discussed only in certain matters. So I don't think that they must be changed according to new conflicts, according to new exact conflicts. What I meant was that in general, they should be discussed not independently from the conflicts that take place. So they should not be made just right for the conflicts. So in the case with Libya, I'm sure that the same must take place. Have I answered your question, or
yeah, thank you.
Thank you very much. We have two more questions, as I can see. I know. Could you please scroll down?
Yes, of course.
Nicholas Centeno, Geneva
Yes.
School of Diplomacy.
Could you discuss further ideas on how to deal with the asymmetry between states? Would war only be just if states are assumed to be on an equal scale and illegal if one state is more powerful?
I think that, yes, the wars must be considered just only if there is assumed to be an equality in all regards. Of course, we understand the fact that there are the countries, the states that are more powerful, that have more territory, or in many regards, they have more protection, maybe more support than the other countries. And that is why, if we are speaking about the modern world and we are not discussing the Middle Age conflicts, the Middle Age battles, it is really important that the principle of the asymmetry of warfare is considered, is taken into consideration. Because if we allow states with absolutely different scales of power to wage war, we will know beforehand who will take the victory. And that is why I think that it is very important to consider the symmetry in all forms: the technological, the ideological, the legal, all forms of asymmetry.
Thank you very much, dear participants. We can see that we have one more question, but since we have a time limit, it's of course it's great to see that we have a vivid discussion, but just save your question for another speaker. Yeah. And we have a comment from Alexander Nikolaevich.
Kwesi, I was a little bit concerned about your statement that a just war is permissible. I understand that that might be discussed theoretically, so to say, but according to the UN Charter, the war is prohibited as a mean to solve international disputes. That is imperative rule.
Yes.
Of course, there are two cases when the Charter provides for the possibility self-defense, for instance, the first example, and the second, when the Security Council adopts decision to use force, full stop. Only two questions. Thank you.
Excuse me very much. What I meant was maybe I didn't use it in the right way, but this statement about the war being permissible was when speaking about St. Augustine and Thomas Aquinas's versions of this theory. Of course, in the modern world, it is not permissible, even for a lesser evil.
Thank you very much. Now we'll jump to another report that starts the topic of human rights. Bocharova Maria, Higher School of Economics, Faculty of Law, second-year student. Implementation of decisions of the United Nations Human Rights Committee in the Russian Federation. Please, Maria, the floor is yours.
Thank you very much. Good afternoon, dear participants. Before I start, I wanted to say that I had a presentation in PowerPoint, so I would be glad if the organizers would...
Yeah, did you manage to send it?
Yes, of course.
Yeah, 1 second then.
Can we ask you to send the presentation one more time in Zoom chat?
Yes. I'm sorry, there is a problem with the internet connection. The file couldn't be attached. Maybe I
okay, well,
send it again.
Share your screen now.
Maria, you'll be able to
share your
screen yourself now.
Okay, thank you. I just need some time to open it. Can you see it now?
Yeah.
The theme of my research and work is the implementation of decisions of the UN Human Rights Committee in the Russian Federation. Firstly, I would like to tell you about the UN Human Rights Committee or Council. It was established in 2006 according to the International Covenant on the Civil and Political Rights, and it replaced the UN Commission on the Human Rights. The HRC has the function to receive individual complaints, to hold communications on them with the states, and to make views on them, which are not legally binding according to the International Covenant on the Civil and Political Rights, and to the first optional protocol to it. Nevertheless, the legal status isn't so clear and sufficiently studied. Comparing with the European Court of Human Rights, only 4,000 complaints are annually received by the Human Rights Council. It is much smaller, and nevertheless, it is an alternative way of protecting human rights. And what is more, there is no deadline of filing a complaint to it after the violation of the right had happened. And this is essential. So that's why more attention should be paid to the activity of the Human Rights Council in the researching works. I researched the legal status of the views of the Human Rights Council. So are the views of the Human Rights Council legally binding or not? According to the International Covenant on the Civil and Political Rights, they are not legally binding. Despite that, in the Covenant, in the Article 2, Part 3a, there is stated that there is an obligation of the state to provide an effective remedy at a national level for a person whose rights were violated. Due to it, the participation of the state in the ICCPR creates certain international obligations, and violations of these obligations are the grounds for international responsibility of the state. We have a resolution on the responsibility of the states, and there in the Article 2, it is stated that the state can conduct some internationally wrongful acts, and therefore a failure to implement the view of the HRC is an omission. Because it is an omission, the state breaches the international obligation, and the actions of the states are wrongful according to the resolution on the state responsibility. And this resolution provides also some legal consequences for the states that have committed breaches of international legal obligations, such as cessation and non-repetition, which is stated in the Article 30, and reparation. It is essential that state may not use references to its national law to justify breaches of obligations. Another explanation is why the views of the HRC are legally binding is that because of the Article 38.1 of the Statute of the International Court of Justice, every norm of international law which is in this article, it can be a legal basis of the breached obligation. The ICCPR belongs to the first category of the sources. Consequently, the state's failure to fulfill its international obligations under Article 2.3a of the ICCPR is a breach of the obligation. As for the Russian Federation, there are some laws that regulate the implementation. The first is the Constitution, where, as we all know, it is stated that international law is higher than the national law, so the supremacy of the international law of the national law is stated. And pursuant to it, there is an opportunity, at least de jure, to implement the decisions of the international committees, even if they are not compliant with the Constitution. Another document is the decision of the Constitutional Court, and number 2048, and it is stated there that though ICCPR contains no articles about the legal status of the views of the HRC, Russian Federation is still responsible for the implementation of the views. And the states chooses the way of the implementation by itself, but as it was mentioned, the state is responsible for it. And the last document is the resolution of the plenum of the Supreme Court of the Russian Federation, number 532, from 10 October 2003. It is stated there that the courts must keep in mind that incorrectly application of the universal principles of the international law may be regarded as a ground for the cancellation of such decision. Due to this, the views of the HRC should be implemented in the Russian Federation.
Maria,
And,
1 minute left.
Okay, and at this slide, you can see their articles of the ICCPR, which are violated in Russian Federation most frequently. So equality before the courts and tribunals, discrimination and liberty and security of person are the articles which are violated most often. Also, I wanted to mention that Russian Federation takes some measures to implement the views, but not of them are taken successfully. So this is all the information I wanted to share with you. Now I'm waiting for questions.
Thank you very much, Maria, for your attempt to analyze this major topic. Dear participants, do you have any questions for Maria? Then thank you, Maria, once again. Now we'll hear out Tkachenko Artem, МГИМО University, International Law, second master's year. Standards and principles for the implementation of religious rights and freedoms by religious associations in the jurisprudence of the European Court of Human Rights. Please, Artem, the floor is yours.
Thank you so much. Hello, dear participants, dear distinguished panel of experts. I'm thankful for this opportunity to present my report. Religion rights and freedoms are an important part of the 1950 Convention for the Protection of Human Rights and Fundamental Freedom. Freedom of thought, conscience, and religion is established in Article 9 of the Convention. This article guarantees the rights to freely participate and practice any religion, both individually and jointly, the right to free learning, the teachings of religion, the right to change religion or belief, the right to freely participate in rituals and religion practices, both publicly and privately. Most of the stated rights are exercised by religion associations, which are created to jointly practice both confessional and non-confessional teachings. In the Russian Federation, regulation of the activities of religion associations is carried out by federal law on freedom of conscience and religion association, which was adopted in 1997, shortly after the Russian Federation joined the Council of Europe. The practice of the European Court of Human Rights under Article 9 is not as rich as under other articles, but is very important since it contains the basic standards and principles for the implementation of the rights guaranteed by the Article 9. It is especially important to analyze the practice of the European Court in relation to the religion associations, since the freedom of activity of such associations shows the level of development of civil society and democracy. In my report, the concept of religion association includes all forms of existence of such association of individuals that take place on the territory of the member states of the Council of Europe. The practice of the European Court of Human Rights shows that most religion organization or association complying of a violation of the Article 9 of the Conventions in the light of Article 10 and Article 11 of the Convention. This can be explained by the fact that the practice of the court has developed an understanding of a religion organization as an association of persons for the purpose of professing a common religion or belief, where confession includes the right to freedom of expression. In its judgment, the European Court of Rights established one of the fundamental principles in relation to the positive obligations of the state arising from Article 9 of the Convention. States are obliged to ensure and maintain religion's freedom, pluralism, and mutual tolerance. This principle also includes the fact that the national regulation should allow adherents of any religion or belief to practice this religion or belief in accordance with the tradition and practices of this religion or non-confessional belief. From the same statement follows the protection of the persons from being involved in religion activities without his or her desire. Protection against such involvement is also guaranteed by Article 9 of the Convention. Religion organization, including states, cannot involve a person in religion activity without his or her consent. This applies to any methods, including the establishment of a church tax or church fee for persons who do not profess a religion, profess a different religion or beliefs, or persons who profess this religion do not participate in religion activities and do not use religion buildings and structures of this religion organization and are not a member of religion organization or society. The European Court of Human Rights in its practice also touch upon the issues of registration of religion association. In its judgment, in the case of Cathedral of Bessarabia and others against Moldova, the court notes that as in relations to religious organization that operates as legal entity, Article 9 of the Conventions is interpreted in light of Article 11 of the Convention. The religion organization entitled to the rights guaranteed by this article. In this regard, the state should ensure through national legislation an accessible, reasonable, and objective mechanism for registering religious organization as legal entities on its territory. The Strasbourg Court considers that a religion organization needs the status of legal entity as an element that will enable a group of persons professing a certain religion to fully exercise the right guaranteed by the Convention. The court also points out the risks that exist when the procedure for the recognition of religion by the state is necessary for the registration of religion organization as a legal entity. The court points out that such a procedure may endanger the spread of minority religions, thereby violating Article 9 of the Article 8 of the Council of Europe Framework Convention for the protection of national minorities. The court also in its practice deal with the issues of the term of registration of religion associations. In the case Religion Community of Jehovah's Witnesses and other against Austria, the court found the violation of Article 9 of the Convention as the Austrian authorities refused to grant legal personality to the community of Jehovah's Witnesses for 20 years. The court indicated in its decision that the public authority has an obligation within the framework of Article 9 of the Convention to reduce the waiting time for obtaining the status of a legal entity to reasonable limits. The practice of the court is also aware of cases that concern the activities of a religion organization in relation to the person whom it hires to carry out labor activities. In Knudsen against Norway, the court points out that since a member of the clergy of an official recognized church must fulfill not only religious but also secular duties, he cannot complain that the latter is contrary to his religion beliefs, since his right to leave from office will be the maximum guarantee of his right to freedom of conscience.
Artyom, 1 minute left.
Yes, thank you. So from all the above, we can conclude that the practice of the court has developed an consolidate the following basic principles in relation to the activities of religion, association, or organization. States are obliged to ensure and maintain religion's freedom, pluralism, and mutual tolerance. The state must ensure through national legislation an accessible, reasonable, and objective mechanism for registering religious organizations as legal entities on its territory. A religion, organization, association, or society must have effective methods of legal protection of violated rights. When carrying out its activities of religion, organization, association, or a society should be free from government interference. Religion organization, including states, cannot involve a person in religion's activity without his consent, and religion association in internal labor relations have the right to set certain conditions that are related to the religion professed by this organization in relation to officials of the clergy. This is all I have to present. Now I am open for your questions.
Thank you very much, Artyom. Dear participants, dear listeners, do we have any questions concerning Artyom's? Yeah, sure.
Yeah, thank you for your research. I have a question maybe relating to the current situation, so to say. We observe today a conflict between religious associations and civil society in Europe, well, in particular in France, as you may know. And the question is, does the European Court or maybe other authorities provide for obligations of religious associations to respect the democratic values and freedoms of the natives in Europe?
Thank you for your question. European Court of Human Rights is entitled to see and analyze the cases concerning the European Convention of Human Rights. In this case, we're talking about Article 9 of the Convention. I'm not sure about your presented by this situation that you present, that the European Court of Human Rights may have the right to analyze this case. And this question has arisen sometimes in the practice of European Court of Human Rights, but European Court of Human Rights is always stands that he is analyzing the cases only that have the basis on the articles of the convention. And the respect of religion and respect of the minorities, as you said, by the religion organization cannot be found in the convention as it is. So it must be reconsidered as the violation of the article of the convention for European Court of Human Rights to deal with such a case.
Thank you very much, Artyom. Yeah, sure. One more question.
Well, I would also like to say thank you for your presentation. And well, I have a quite general question. You said that people can't be forced to participate in religious organizations, but I'm quite sure that there are various situations when they are forced. So what legal responsibility is exists in European Court of Human Rights for this matters when that rights are?
Can you please repeat your question? I don't hear it well.
Can I do this?
Yes, take a microphone.
You said that people can't be forced to participate in religious organizations, but I'm quite sure that there are various situations when they are forced. So what legal responsibility, if it exists, of course, is, well, in European Court of Human Rights for this matters?
When someone is forced to exercise a religion, that must be, first of all, the case of the national courts to decide. Then with all procedures came to the place, and when the European Court of Human Rights is dealing with this case, this must be considered as violation of Article 9 and Article 8 of the Convention. And then European Court of Human Rights will deal with this case after all the national courts will be, after all the procedures at the national level will be set in place.
Thank you. So we have our time limits and we have to jump to another report. I'm sure that these speakers will definitely have a question from our first speaker from Geneva, Bayezid Emily and Zotova Taisia, МГИМО University, International Law, 4th year students, International Legal Status of Crimea. The floor is yours.
Dear colleagues and moderators, thank you for the opportunity provided to us to raise one of the most controversial issues being constantly discussed in the legal society. The topic which we're proud to present to you is the following: interpretation and implication of Article 2nd of the UN Charter, the Crimea issue.
Before we pass on to the modern status of the Crimea Peninsula and the US participation in the coup d'etat in Kyiv in 2014, from the international law perspective, we should point out some historical events of legal significance which provide insight into its position nowadays. First, we should clarify that historically Crimea was a part of the Russian territory for a long time, especially since 8th of April 1783, when Catherine the Great signed the manifesto on the annexation of the Crimean Peninsula, Taman Island, and the entire Kuban side under the Russian state. Second, we should touch upon the acts aimed at changing the legal status of the peninsula, and the two main decrees of the Soviet era are listed on the slide. These acts are of particular importance due to the fact that they were later admitted as having no legal force on the grounds of violation of the constitution of the RSFSR and legislative procedure. These provisions were outlined in the 1992 resolution of the Supreme Soviet of the Russian Federation, called on the legal assessment of decisions of the highest bodies of state power of the RSFSR on changing the status of Crimea. Thus, we could infer that Crimea is an undisputed part of the Russian territory, and its transfer to Ukraine in 1954 was legally ungrounded. In violation of the 1991 plebiscite results, the Ukrainian authorities unilaterally entered Crimea into its territory as an autonomous republic, which constitutes annexation.
Now we're going to cover the prerequisites of the plebiscite and those causes which led to such results. First was the 1991 plebiscite mentioned before. During this plebiscite, 93% of participants voted for the independence of Crimea from Ukraine. Those results were ignored by the authorities in Kyiv, which subsequently led to discontent with the Ukrainian government that was clearly expressed by the peninsula population. As the second prerequisite, we could highlight the ban on regional political parties. Due to the absence of such parties, ethnic Russians failed to struggle for their rights. The principal demand of Russian-speaking people consisted of recognition of Russian as a state language. That claim found support in campaign promises of various Ukrainian politicians, but did not have any practical application. These two issues are crucial for the recognition of the self-determination right of the Crimean people. Under the international law doctrine, the folk is entitled to self-determination not only in case of colonial dependence, but also in case of massive human rights violations or discrimination, if there is no other way to change that situation. Since the Ukrainian cultural policy consistently violated ethnic Russians' rights within the Crimean Peninsula, the Crimean people expressed their willingness to join Russia. This incident complies with the so-called remedial succession international law doctrine, according to which self-determination through succession is allowed. Later, the remedial succession doctrine was reaffirmed by the United Nations. The ICJ did also have recourse to this doctrine in its advisory opinion on the Kosovo case. To summarize, the urgent need of the Crimean people to exercise their self-determination right fully corresponds to the norms of international law, confirmed by the doctrine and the practice of the UN ICJ.
The plebiscite on 16th of March 2014 was the most important legal ground for the Crimean people to rejoin Russia, since the vast majority of this peninsula population expressed the will to enter into the Russian state. Under Western law transition, holding the plebiscite is considered to be legal, even if that is not provided by the constitution of the state where that takes place. Consequently, the Crimean plebiscite should be admitted as legal. Additionally, the plebiscite doesn't violate the norms of international law for one more reason. According to modern international law, declarations of independence resulting from such plebiscites are also held to be lawful. Besides, subject to certain conditions, not only the whole population of a state could be recognized as folk, but also a particular portion of it under modern international law. The Crimean people do meet all the requirements to comply with the category of the folk entitled to self-determination. The international law admits such cases when the self-determination right could not be exercised without leaving the state of residence and entering another state. Those situations occur inter alia in the particular portion of the population is harassed on cultural grounds. We should also mention that the preservation of people is impossible without preserving their culture, language, beliefs, way of life, and historical memory. Therefore, not only genocide and physical extermination of the people constitute the violation of human rights. The state policy eradicating all the listed elements of the spiritual life of the people should also be considered as violence against people.
Now we're going to talk about why did the Obama-Biden administration violate international law during Maidan events. The coup d'etat in Kiev, which took place on 22nd February 2014, led to authority pro-Western radicals. We should also point out that the constitutionally elected Ukrainian President Yanukovych was unlawfully replaced by Turchinov, appointed by Rada in violation of the constitution. We should also mention that there was a significant contribution of the United States. These circumstances should be assessed as a breach of the principle of non-interference in the internal affairs of a state, under Article 2 of the UN Charter. The thesis about the US participation in the coup d'etat in Ukraine is not just an unfounded statement. On the contrary, it is based on several factual circumstances providing such an intervention. First, a whole group of the US Embassy employees in Ukraine coordinated the actions of the opposition, thereby taking part in organizing protests against the constitutionally acting government. The former Prime Minister of Ukraine, Azarov, reported the following. A group of senior officials of the US Embassy in Ukraine undertook the coordination of the opposition actions. It was they who were visited by the oppositionists every day. It was they after whom the oppositionists went to negotiations with Yanukovych, and it was they who reported on such negotiations. Second, senior US officials have openly supported the leaders of such protest movements. Moreover, they also put pressure on the current Ukrainian government. The aim was to prevent any measures of suppressing protests, even those that are legal. Former US Vice President Biden notes in his memoirs that he regularly demanded from President Yanukovych to exercise restraint toward protesters. The US Vice President even called to the Ukrainian president and demanded that he resign. Last, we should also mention that the US provided financial assistance to the protesters. Although it cites the fears in various sources, the fact that it was the US that was funding some oppositional could be confirmed by different data. Those actions do constitute an interference in the internal affairs of a state. We should point out that the term interference in the context of Article 2 of the UN Charter means not only cases of armed force usage. Any interference in the affairs constituting the internal competence of the state also constitutes such interference.
There exists only one exception which allows neglecting the principle provided in the second article of the UN Charter. There must be a threat to peace, violation of the peace, or an act of aggression. As we could see, none of these reasons was presented in our case. Hence, the USA actions do constitute the breach of obligations set forth in the second article of the UN Charter, since there was an interference in the international affairs of a state by the US side. Further, we should point out the policy of the radicals who came to power because of such interference. Their very first steps in the state arena demonstrated to the Crimean people the following: the eradication of Russian culture, Russian language, and historical memory of the Russian and Ukrainian people is one of the most important scopes of their activities. And from this perspective, the Crimean people had every reason to decide about the impossibility of ensuring the right to self-determination within the Ukrainian state. To conclude, we could infer that the reunification of Crimea and Russia does meet all the requirements to be legally grounded. Thus, the transition of the Crimean Peninsula to the Russian jurisdiction does not violate the norms of international law by no means.
So, thank you very much. Have you finished?
Yes, thank you for your attention.
Thank you. Dear participants, do we have any questions to our speakers? Yeah, sure, please.
Thank you, dear participants, for your research. There is no doubt that Crimea is ours in a sense, but the question is, you have claimed and you have proved that the United States have violated international law while the Maidan events? And how come that the United States, having violated the international law, stay unpunished, so to say? Doesn't it demonstrate the uselessness somehow of the current system of international law?
Thank you for your question. It demonstrates the policy, not law. Demonstrates as the policy, not the law.
Yeah, sure. We have a comment from Alexander.
Thank you for the question. It's really very common event when the violation of international law takes place, but there is no responsibility for this violation. For instance, the military intervention of the United States in Vietnam, it was obviously an intervention which was accused later on, even by former US administrations, but that was not punished. The fact that the responsibility was not realized does not mean that the violation of international law disappeared. Thank you.
Thank you, Alexander Nikolaevich. Dear speakers, do you have something to add?
Actually, we have one more question in Zoom chat.
Yeah, please read it out.
From Nicholas. How do the presenters think the presidential election of the Biden in the United States affect the situation moving forward?
So what do you think?
Well, we think that his influence is hard to underestimate, but we hope that the relationship between the countries will not be any more complicated than they are now and that they were several years ago during the circumstances we've just talked about.
Yes, because we hope that Biden is not going to spoil the relationship.
Thank you, dear participants. If you have an opportunity to ask your question orally, please do so. You do not need to write your question in our Zoom chat. So we have a question from Kuyeza. Could you please?
Yes, thank you. So my question is, are there any facts confirming that the United States sponsored the opposition in Ukraine?
Well, yes, because it is noteworthy that in the end of last century, US Congress and the administration of USA, they began to express concerns about the possible revival of Russian imperialism. And so they used some methods of public diplomacy aimed at developing democracy. And so Ukraine became first in terms of the amount of finance invested by the US government in this activity, in this particular activity.
Also under the law of 1996 on the financing of US foreign policy for the promotion of democracy, in the ex-USSR countries was allocated around $641 million. Ukraine, from this amount of allocations, accounted for $225 million. Also, many official documents of the 1990s indicated that Ukraine would eventually join the European Union and the US should contribute to this. The general tool for implementing public diplomacy programs has become the US Agency for International Development. Back in early 1990s, its representative office was opened in Ukraine, which has sent budget funds to local partners through a network of American organizations.
Thank you very much, dear speakers. So since we have our time limit, we have to move on to the next report. The next speaker explores the correlation between the original concept of human rights in Islam and the concept of universal human rights at different stages of the Organization of Islamic Cooperation functioning, as well as the activities of this organization. Valeria Pchelintseva, МГИМО University, International Law, second master's year. Valeria, floor is yours.
Human rights concept and universal human rights standards on different stages of the functioning of the Organization of Islamic Cooperation, further referred to as OIC. The both of our OIC has concept of human rights and Muslim states relativist concept. We believe that there is at least three thematic justifications for such a study. First is its contribution to the theoretical relativism and universalism correlation issue. The second is its contribution to the practical issue of human rights in Islam and universal human rights concept approximation. The third thematic justification could be the contribution to human rights protection and promotion in national Muslim communities, which is especially timely for the Russian Federation given the structure of its population. We would like to introduce you to the major findings of our study, first of which is that since the second half of the 20th century, the concept of human rights in Islam has been gradually moving towards conformity with the universal standards. Our starting point is the prevailing opinion in national doctrine of the second half of the 20th century that much needs to be done before the two approaches, if at all, will be led to compatibility. We would like to quote here Abul Ala Maududi, a Pakistani philosopher and jurist who wrote in 1976 that the resolutions of the United Nations cannot be compared with the rights sanctioned by God because the former is not applicable to anybody while the latter is applicable to every believer. On their behalf, the Western countries were quite skeptical about the regional instruments on human rights. In its memorandum, Committee on Legal Affairs and Human Rights of Council of Europe, as late as in 2016, writes that the provisions of Dhaka Declaration are based directly on Sharia law and make no reference to international instruments, which is seen as its disadvantage. The Cairo Declaration is seen as a more progressive, but still a controversial instrument. OIC assumed the mission of human rights protection and promotion in 2005, the same year when the Covenant on Human Rights of a Child in Islam was adopted. And comparing the Covenant to the Cairo Declaration, Aslan Bashid outlines that Sharia stays one of the principles of the Covenant, yet not the basis of its interpretation, as the case was with the Cairo Declaration. Not to mention the direct reference to the United Nations Convention on the Rights of the Child in the preamble of the discussed Covenant. An important change is taking place right before our eyes. The revised version of the Cairo Declaration is about to be adopted by the OIC members, text not yet published. Some scholars still have access to it, and in his study, Turan Kayaoglu, in September 2020 outlines that the new declaration protects 26 out of 32 rights that are enlisted in the Universal Declaration of Human Rights compared to 23 rights in the Cairo Declaration. At the same time, some of the rights were attributed not only to men, but also to women, such as freedom of movement and residence and right to seek asylum from persecution. Some of the controversial provisions, such as recognition of men as head of the household, and protection from conversion away from Islam have been excluded from the text of the declaration. To conclude on this one, we would like to mention that since 2005, the number of OIC members bound by the provisions of CCPR and CESCR has risen from about 75% of the countries to about 90% as of May 2020. The newly adherent countries include Bahrain, Qatar, Oman, and Pakistan. Our second conclusion was that the nature and procedures used by the Independent Permanent Human Rights Commission of OIC allow it to serve as an intermediary between Muslim states and international community. Firstly, OIC has consultative status for the Muslim states. Secondly, it has observer status in the UN. And this involvement on both levels helps the organization through its Independent Permanent Human Rights Commission to resolve the conflict between the legal techniques through reference to both universal standards and Islamic doctrine. which refers us to our third conclusion, being the activity of OIC does contribute to human rights protection and promotion in its member countries. We would like to give two examples here. The first is the study on human trafficking in OIC countries performed in 2016, which has a reference to the protocol to prevent, suppress, and punish trafficking in persons, especially women and children, and a recommendation for the member states to adhere to this international instrument. Another example is OIC resolutions from the 5th Conference of Ministers on Marriage and Family Institutions with the study on gender identity attached to it. This contains official position of Muslim states, and we believe that it is important that we have a uniform position of Muslim states instead of their diverse declarations in order to engage in a dialogue and provide acceptability of standards for Muslim states as well. Our fourth conclusion is that in certain cases, OIC unfortunately lacks legitimacy or authority that is necessary for effective implementation of human rights goals, while certain measures proposed by the OIC could be described as counterproductive. Our first example here is field visit to Azad, Jammu and Kashmir. Unfortunately, the field commission didn't have authorization from the Republic of India, which made it only rely upon the testimony of persons fleeing Jammu and Kashmir to Pakistan. Unfortunately, such a study could not be considered trustworthy or objective. The second example is the study on gender identity, once again, which has a recommendation of reducing funds given to UN agency. We could characterize it as counterproductive and unfortunately in conflict with the obligation of the states to cooperate.
Valeria, 1 minute left.
Thank you. Which is protected by the UN Charter. Our final conclusion is that further studies and engagement with OIC activity on behalf of all members of the international community are necessary. The possible fields of further research are the newly adopted, the ones that are about to be adopted, revised declaration and revised covenant on human rights of a child in Islam, further developments concerning most controversial rights and freedoms. We've got studies and reports on this. And finally, the results of the work of Women Development Organization, which has started to work in the autumn 2020 due to 15th ratification by the Cameroon of the statute of that mechanism. We thank you very much for your attention. We are ready to answer any of your questions.
Thank you very much, Valeria, for such a vivid and dynamic report. Dear participants, do we have any questions or comments? Probably our colleagues in Zoom. Okay, thank you again. Now let's move on to the next report. It will be presented by Andreas Neff, University of St. Gallen, Switzerland, the future impact of subsumption automation with artificial intelligence, legal tech on international law. The report describes the features of using legal tech and the possible consequences of implementing these technologies. Andreas, the floor is yours.
Thank you very much. So I hope you can see my presentation.
Yes.
Very warm welcome to Russia from Switzerland from my side, and thank you very much for this opportunity. My name is Andreas Neff, and I'm a law student at the University of St. Gallen. I have been involved in the field of legal tech for about 3 years now. In the next few minutes, I will introduce to you a field that will occupy all of us in the future. Legal tech is an area that runs through all legal areas. There are many new opportunities, but there are also many risks. That is why it is so important for me to give you, as the next generation, a first insight into the field of legal tech. The short presentation is structured as follows. First, I will explain what legal tech actually means. As soon as the definition of legal tech has been established and you know what the current situation looks like, I will explain the direction in which the field of legal tech will develop in the near future and what therefore needs to be taken into account. After that, I will explain to you the opportunities and risks this development brings with it. The presentation will be rounded off with a list of tips that I can give each of you on the way to be prepared for your future legal or international affair career. The meaning of legal tech. Legal tech is defined as the IT-supported technology that supports or automates legal work processes. The actual field is already over 25 years old and used to be called legal informatics as well. With the advent of the first computers, some people already tried to digitalize processes, but the possibilities of digitalization were still very limited. In the meantime, there are many individual ready-made or experimental products that focus on specific process steps in legal services. As an example, I've listed here some areas, for example, document automation, which helps the lawyers or the client to improve the customer journey while creating contracts. For example, the user only has to give these inputs step by step, which individually need to be in a document. All other static clauses and sentence fragments will be placed in the document by the software itself. Furthermore, cryptography allows us, for example, to store digital document on the blockchain in a forgery-proof way. Predictive legal analytics can also massively improve the access to justice by enabling litigation and arbitration funders to compare an existing case with past cases. Such a tool can predict the likelihood of a case turning out positively or negatively. This can give the litigation and arbitration funders more confidence to make an investment. Especially with such tool, it is very important to observe ethical principles. Such tools can only predict a probability based on hard facts, but should never directly influence a decision, or even be perceived as an automated decision. In the end, a case should or must always be evaluated individually and weighted subjectively. Therefore, a judge's decision should never be automated, in my opinion. The future of legal tech. Currently, there are a large number of independent standalone solutions, which do not allow lawyers to manage a process with one single software. There are already management solutions on which, however, API links to legal research tools or document automation tools can only be created with a lot of effort. Therefore, in my opinion, it is very obvious that in the future, a major player will or should put together an overall solution, as you can see on the right side, from existing products. This complete solution already has all the links to the most diverse tools, which simplify the work of a lawyer by a lot and massively accelerates in process. The opportunities and risks. Now the opportunities and risk which such a software brings, first of all, the chances. An integrated complete solution can bring many synergies with it. For example, not every product needs to have its own foundation, such as setting up a database, etc. This avoids double or multiple work tasks, especially in less difficult areas such as all accounting and actual administration stuff that individual products bring with them. The most difficult part of bringing such a product to the market is building up the trust in the technology that is being made. It takes a lot of time and effort to gain the trust of lawyers or clients with an overall product one can benefit from adding another subproduct with more or less the same trust, with the same trust value, without starting from scratch by just using the same branding. Furthermore, the system can be equipped with a uniform security system so that all products fulfill the same security requirements. A political task force can also be set up, all working with the same interest in the advancement of law about the use of technologies in legal systems. The main points of criticism of such a centralized software are clearly the lack of flexibility. Furthermore, there is a great risk that a central point of attack will arise, which could have serious consequences in the event of a cyber attack. I hope I was able to give you an insight into the field of legal tech and would like to share the following points with you on your way. First of all, please always ensure that human rights are respected when using automated systems or technology and digital solutions. Secondly, initiate as the next generation the dialogue on an international level and try to establish a common global understanding of the usage of technology in the legal system. And third, stay open for digital developments to handle more processes in less time and improve, therefore, the access to justice. Thank you very much for your attention.
Thank you, Andreas, for such breakthrough and up-to-date information you gave us. Dear participants, do we have any questions concerning Andreas's speech? Yeah, we can see a raised hand. Yeah.
Yeah, thank you so much for your speech. And I would like to ask you a question. So you know that in some spheres, for example, in civil law, some of the measures have been implemented. I mean, for example, smart contracts, and they are being used in different countries. So my question would be, is there any concrete analog of smart contract implemented in international law, but in case of international treaties? Thank you.
I don't know if there is already an implemented solution in an international law case. Normally, these are solutions which always be used by individuals, for example, individual law firms and so on, but not by an overall organization which works on international law.
Thank you. Any more questions, dear participants? Okay, then then we'll move on to the next report. And after this report, we are going to have a short, well, we'll say 20 minutes break. Semtseva Stanislava, Financial University under the government of the Russian Federation, Faculty of Law, first-year student, cooperation of states in a field of combating money laundering. Please, Stanislava, the floor is yours.
Thank you for presenting me, and I sent a presentation, if you don't mind. Thank you. Thanks. So the World Economic Crime Survey for 2020, conducted by the PricewaterhouseCoopers network of companies, notes that the level of economic crime, both in the world and in individual states, is now at a record high. And while currently there are two directions of protecting the economic security of states. The first one is ensuring macroeconomic stability through economic administrative methods, and the second one is countering criminal, shadow, and other economic processes by regulatory and legal means. And as part of the Global Economic Crime Survey, PwC experts analyzed various offenses from misappropriation of assets, bribery and corruption to cybercrimes, and the problem of money laundering. And well, I think that the last one is apparently an issue because the number of such offenses in the world from 2018 to that year increased till 11%, and in Russia it is 15% of all economic crimes. And it should be noted that this data is well inaccurate because it's quite difficult to detect such crimes. For example, according to the Judicial Department of the Supreme Court of the Russian Federation, for the first half of that year, only 9 people were convicted on that type of crimes. Despite the high risk of money laundering, international actions in this field, they face the problem of no general concept. And this is mainly to the peculiarities of national legislation. The Vienna Convention on the Law on Treaties of 1969 helps to solve this problem due to the Article 33 of that convention. If texts are being compared differently, the values that best matches all of them is taken. Well, given the complexity of identifying black money in the international financial system, this international cooperation in this field is implemented through FATF, that's a Financial Action Task Force of Money Laundering, as well as other organizations that you can see on the slides, and because I will not list them all. And also, for that matter, international community has adopted a number of documents that you can also see on the slide, because there are a lot of them. But I can say that, to my mind, they're a bit well old, and they should be reinvented, so they will be really helpful. Also, there is a big problem that none of these documents really say something about legal responsibility for committing such type of crimes. However, the FATF recommends establishing criminal liability for it, and when this is not possible, civil or administrative responsibility. The UN General Assembly stated that as national and international security are becoming increasingly interlinked. I'm sorry. So as they are increasingly interlinked, the most effective way to implement interstate cooperation in this area is requesting for legal assistance. But unfortunately, this is quite difficult, and there are cases when such requests are sent late, or the relevant authorities of foreign countries take too long to process them. And also it is quite important So an important aspect of cooperation between states in the fight against money laundering are so-called mutual assessments. You can see on the slide that these are peer reviews where participants from different countries, they rate each other, and this benefits the description and analysis of national systems and helps to further strengthen them. And also the process of de-offshorization is quite an important issue. Well, because offshore zones helped criminals to convict such crimes. And a few years ago, interstate organizations developed recommendations and special methods. And so by October 2019, there are practically no offshore zones in the classical sense of the term. In conclusion, I would like to note some of the measures that seem to be appropriate to regulate this legal aspect. This is ensuring that interstate obligations are properly implemented, increase understanding and compliance with beneficial ownership requirements, and ensure the financial institutions apply targeted financial sanctions and freeze assets without delay in accordance with the established UN sanctions lists and nation legal instruments. Well, that's all I wanted to say. Thank you for your attention. I am ready to answer all your questions.
Yeah, thank you very much, Stanislava. Dear participants, questions, please, before we make a short break.
Please be more right. Don't hesitate to ask questions.
Well, could you please turn off the demonstration of speaker's presentation so that we can see the chat, Zoom chat? Well, no questions in Zoom chats, but we have a comment from Alexander Nikolaevich.
Oh, probably a small questions. Thank you for your presentation. Have you read the publications of МГИМО postdoc, PhD student, Maxim Pechenko, about money laundering and of international legal means of combating money laundering? Have you read his articles?
Well, unfortunately, I haven't read this particular article, but I've read quite a lot of others, and well, I'm quite sure that I will read this one afterwards.
It was about 10 years ago.
Well, then I think that I haven't read that because I was trying to read articles that are quite recent, and because this problem is really urgent, as I said during my presentation, we cannot say how many people really convict this crime because it is very complicated. It is a shadow economy, and there is lack of practice.
Yes, Stanislav, the reason I asked the question, because as I could see, if you have read these papers, probably your presentation might be more, I would say, more mature, legally mature. But that is natural growth of profession. That is okay. Thank you.
That's true. Thank you, Alexander Nikolaevich. Dear participants, any more questions? As Dmitry Vladimirovich mentioned, do not hesitate to ask your colleagues your questions. And yeah, that's true. Okay, so since no one has any comments, coffee break for 20 minutes. I advise you, colleagues who joined us in Zoom, not to leave the conference room in Zoom so that we don't have to waste time letting you in. 15 minutes for a break. Thank you. Dear participants, we are back from the break, and we're going to proceed with the next report. Semenova Ekaterina, Lomonosov Moscow State University, law faculty, first-year student. Human rights and fight against the climate change, the new reality. Please, Ekaterina, the floor is yours.
Good afternoon. Thank you for the opportunity to participate. Climate change has become a pressing issue in both international and national law in recent decades, and the question of the relationship between human rights and climate change seems relevant since the totality of natural and anthropogenic factors causing these changes has a certain effect on human rights. The United States Framework Convention on Climate Change and the Paris Agreement are international instruments governing the parties' principle and obligation concerning this issue. The Framework Convention is a consensus among developed and developing states on adapting and creating new international instruments to changing realities. According to the convention, states are directly responsible for climate change related actions and for adverse consequences which can be caused by the parties' inaction. The Paris Agreement complements the convention and in some respects strengthens the regulations of states on climate change. In particular, it's establishing a mechanism to contribute to the mitigation of greenhouse gas emissions and support the sustainable development of parties. In agreement, the emphasis is also placed on the national contribution of various public and private enterprises because they are big greenhouse gas emitters too. It's important to know that convention differentiates between developed and developing countries, and the former are the major emitters of greenhouse gases, and the overall reduction of in air emissions depends heavily on them. The developed countries shall assist the developing country parties because the latter ones are particularly vulnerable and they are more likely to be victims. Among developing countries are, for example, island countries, drylands, lowland countries, and all these countries are at risk of climate change in the first place because indigenous people often live in developing countries, and the question of protection of the rights of indigenous people is also very relevant. The links between human rights and climate change should be highlighted since the Framework Convention made little mention of them, I mean human rights. The whole spectrum of human and civil rights was one of the main objects of protection at the national and international levels when it came to the impact of the climate on the world. Human rights, which I'm going to refer to, are placed in the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights. So basically, one of the most important rights threatened by climate change is the right to life. And when the life of a person is being ruined because of the natural disaster, other rights are being violated too. For example, the right to an adequate standard of living, it includes the right to an adequate food, clothing, housing, and the continuous improvement of living conditions. All these rights are being violated when someone's life, nation's life, nationality's life is also being violated by the climate change. It's also worth mentioning the right of people to water and to health, since climate change directly affects the level of cleanliness of water and air, and this directly affects the birth rate and mortality rate and the total life expectancy of the population. It's also worth noting that the most vulnerable categories of the population are children, the elderly, disabled, women, and the priority of countries is to protect these social groups. And here it's worth talking about the obligations of the parties in domestic and international policy. States within their territory are obliged to inform the public and thereby prevent possible environmental disasters, and they shall also prevent casualties. It's also crucial for the parties to ensure the interaction of society and the state, the prompt protection of violated rights of the population due to climate change. There also should be an international cooperation between the parties, exchange and experience of information and personnel in the field of climate change and development programs, because very often climate change covers and violates the rights of several countries and at the same time. For example, warming temperatures of the seas when several coastal countries are threatened at once. So warming temperatures affect several countries at the same time. To sum up, it's necessary to emphasize once again the involvement of absolutely all states in the problem of climate change, and the fact that parties have domestic and international objectives to solve this problem. And the protection of human rights is the core of all the goals and objectives which the states pursue. In the new realities, rights encourage states to fulfill their climatic obligations and to ensure effective legal protection of nationalities and individual citizens. At the same time, rights themselves are becoming reinterpreted in the light of climate change because they expand their legal framework, they become more relevant, and without awareness of these rights, social groups which are at risk from climate change would not be able to receive the right of protection, the right to be heard, and the states would not be motivated to comply with the obligations under the Convention and the Paris Agreement. Changes in human rights and their protections at the international and national levels in relation to climate change are currently quite successful, and in future, with the adjustment of monitoring and protection mechanisms, the climate dimension of human rights will enter into the international and national law firmly, as can be said, will be based on the programs and obligation of the states parties to the Convention and the Agreement. Due to compliance by the countries with the Convention and the Agreement, there remains hope for the possible future without the climate and related man-made disasters, which is currently sought by the parties. That's all for now. Thank you for your attention. I'm ready to answer your questions.
Thank you very much, Ekaterina. So would our listeners and participants have any questions for Ekaterina? Well, we have a participant from financial university under the government of the Russian Federation. Alexander.
Okay, thank you for your urgent research. And my question is, could some international organization, maybe specialized agencies, UN agencies, impose some sanction on countries if they breach the environmental law, if they breach the human rights in the environmental sphere?
Thank you for your question. I think that yes, there is a possibility of that. And I would like also to mention that actually there can be a protection of the human rights in ACHR. So basically, yes, it can be possible.
Thank you.
We have one more question in our Zoom chat. Could you please open it?
The question is
Nicolas
from
Centeno.
Nicolas.
Nicolas, could you please ask a question orally?
Yes. My question is, how should states combat the growing number of environmental refugees that have to flee due to climate change issues?
Thank you for your question. In my personal opinion, if there are some climate change refugees, it means that the states from which these refugees came from, they do not fulfill their obligations according to the convention and the agreement. Hence, there is a problem within the country from which these refugees are escaped, and there should be some, and this country should be like, I don't know how to say it exactly. It should be responsible for the fulfillment of the program, because almost every country, or at least either ratified or accepted the convention. Hence, each country has the obligation to protect its citizens, and there should be a responsibility of, as I have said, of the country from which these refugees escape. And in the terms of the country to which they escape, it should provide for these refugees decent living, clothing, I don't know, food. So there should be all, they should be in the convenient, they should all be in the convenient circumstances until the case of these refugees is settled.
Thank you very much. We have a comment from Alexander Nikolaevich.
Thank you very much for presentation, and thank you for the question. In fact, the environmental refugees issue is really very, very important and deserve really great attention on behalf of the international community as a whole, and also, of course, for young generations of future lawyers. Of course, that is really very important issue. And thank you for posing this question. I recommend for all students probably to read the book, which is published by Cambridge School Publishing House, and it is in English. The authors of this book, the book is devoted to environmental refugees, and the authors of the book is to the left of me, Dr. Ivanov, Dmitry Vladimirovich, together with his co-author. They compiled the relevant international documents which relate to this particular problem, and they try to analyze them. I think the book is really very useful. A small comment. Thank you.
Thank you very much, Alexander Nikolaevich. So, do we have any more questions to the speaker? So no questions, then we move on. The next, no less interesting report is devoted to the topic of the challenging domain of autonomous weapons under international humanitarian law. The author will try to explain us what autonomous weapon systems are. We'll try to identify current regulatory issues and forecast future ones. So, Centeno Nicolas Sol, am I right with the spelling, Nicolas?
Yes.
Yeah, from Geneva School of Diplomacy and International Relations.
With spelling is okay. Is it okay with pronunciation?
with
I don't. Everyone pronounces it differently. It's fine. So, hello, good day, everyone. My name is Nicolas Centeno. As mentioned, I'm from the Geneva School of Diplomacy and International Relations. My report today is on the challenging domain of autonomous weapon systems and autonomous weapons under international humanitarian law. So next slide, thank you. So firstly, I'll give a brief introduction as to what autonomous weapons and autonomous weapon systems are. They're defined by the International Committee of the Red Cross as weapons with autonomy in critical functions, these critical functions being the ability to sense, decide, and act. Sense being recognizing surroundings of conflict, decide being determining between threats and non-threats, and act being the actual launching of an attack. Now for this report, I've further clarified, I've defined autonomous weapons as a weapon with the ability to launch and attack without specific human involvement, meaning they do not need a commander or military personnel to approve the attack. And autonomous weapon systems, also referred to as AWSs, as human-in-the-loop systems that require human activation in order to launch the attack. And human in the loop, meaning while a human is not doing the function, they're monitoring the weapon system as it does it. So now with this understanding, I'll move on to the challenges. The first challenge that I've outlined is adhering to the principles of international humanitarian law. Now, the three main principles are distinction, proportion, and precaution. First, distinction is the ability to distinguish between military objectives, objects of civil property, and protected people. Now, the issue with autonomous weapons and following this principle is obviously conflict is a very unstable environment. Things are changing in the matter of seconds. And so autonomy doesn't have the ability to adapt to this instability. So what may be a threat, what they may program as a threat in one circumstance may not be a threat in a different one. So autonomous weapons have a difficulty in making these distinctions. On proportion, that's the ability to determine whether an attack provides a necessary military advantage in relation to its effect on civilian population and property. And the issue with autonomous weapons and AWSs in proportion is that we currently don't have the technology available for these systems to truly make this determination. They don't have the intelligence to do this. And it's similar with the principle of precaution. Precaution requires that before an action is taken, an assessment must be made on whether this action would violate international humanitarian law. But again, the issue conflict's very unstable. And while you can program certain assessments into an autonomous weapon or system, you can't program every single hypothetical situation. So we can assume that there are going to be circumstances where an autonomous weapon system cannot follow this principle of precaution, because these principles are very deeply rooted in human judgment. And so that's why this becomes an issue, because autonomous weapons and AWSs don't have this factor of human judgment to make these decisions. So it's difficult to assume that they can follow these principles. So next slide, please. Thank you. So an understanding that they're not going to be able to follow, we move on to what an acceptable margin of error would be under the law. Now, autonomous weapons and AWSs have under a 90% success rate. The success rate varies from weapon to weapon, but none of them have reached 100%. So we can say with certainty there is going to be error. And if there's going to be error, the question becomes what's going to be acceptable under the law, how much violation is going to be acceptable. Currently, the Red Cross has allowed this to be determined by state determination, where states determine for themselves how much error they'll allow their weapon systems. However, this creates issues because of the different variations between states. So in an international conflict, what may be a violation for one state may not be a violation under another state. So that creates issues in the law. Now, because of this lack of 100% success rate, some states and organizations like the Organization to Stop Killer Robots, for example, have called for a complete ban on autonomous weapons and AWSs in conflict. However, this conflicts with state interest. So a good middle ground is a universal standard which will determine the acceptable margin of error of AWSs and autonomous weapon systems in every conflict. So next is determining responsibility and intent in the case of violation where there's need for prosecution. There are three areas where responsibility can fall under: the state, commander, and programmer. So with the state may be responsible for violations under the law of state responsibility. However, this is an issue because the same law gives plausible deniability to the state because of the autonomy. Since the state is unaware of what the autonomous system might do in a circumstance, they have deniability under the law to not be prosecuted in case of a violation and civilians are killed or something. So next is a commander. Commanders may be responsible for violations due to human-in-the-loop attacks where they actually approve an attack. But in the case of autonomous weapons that don't have commander approval, it's hard to find responsibility. The next is programmer. Since programmers are responsible for autonomy, it could be said that they're responsible in the case of prosecution for the attack. However, the issue is that programmers aren't in the field of conflict. They don't have the previous knowledge of how their autonomous weapon system will be used. And so it's difficult to prove intent in that case. So these are the three main challenges that I've outlined of regulating autonomous weapons and AWSs under international humanitarian law. But it's very necessary that we start to do this because they're clearly becoming a permanent means of modern conflict. Now, member states were supposed to meet under the United Nations Convention of Certain Conventional Weapons to address these issues, but that was canceled due to the COVID pandemic. But moving forward, it will be necessary for the states to make a consensus, address these challenges, and regulate autonomous weapons and autonomous weapons systems under this convention and under international humanitarian law in general. Thank you very much.
Thank you, Nicholas, for your report. I'm sure that your colleagues we'll have some questions for you. Dear participants, do not hesitate to ask questions. Yeah, sure.
Thank you for your research. It was really interesting. I may have misunderstood something, but on the last slide, there was, well, determined responsibility, and there were three, I don't know, three subjects who may be responsible for an attack. So state, commander, programmer. State, okay, understandable. State can be found responsible, but commander and programmer, they are individuals and they are not subjects of the international law, as far as I understand. So how can they be found responsible for an attack on their international level?
Well, it's sort of similar to the case of criminal law. I mean, international law does prosecute criminals. We can see that with individuals with the case of the International Criminal Court. In this case, it's mainly referring to more domestic prosecution, but that domestic prosecution would come at the, I guess, request of the international community, which sort of fixes it under international law, if that answers your question.
Yeah, thank you.
Dear participants, we have a question from Tamara Posadkova.
Yeah, hello. First of all, I think, well, I'll hazard a guess that I see a fellow Jesper here. So this was one of the issues for the last year JASEP competition, and I spent like 6 months researching it. So, yeah, well, so I have several questions. First of all, while you're talking about distinction and proportionality and precaution, you said that the autonomous systems that we have today are maybe unable to comply with all the criteria because they are not technically developed enough. Well, first of all, my first question would be if the technical development, if further technical development is possible, because we can't predict if, I don't know, if in 5 or 10 years, someone will create an autonomous weapon that will be capable of complying with all the with all these criteria posed by international humanitarian law. Will it be legal? And if we don't know if such a weapon can be in fact developed, how can we decide on its legality or illegality now? Because you said that this question requires urgent regulation. However, we don't really know the technical capabilities. That is my first question. My second question would be, would you say that the countries that are now using autonomous or semi-autonomous weapons like Israel with its Harpy or Korea with the CGR-1 that is deployed along the Korean border, would you say that those countries are violating international law by using this kind of weapons? And my third question or comment would be that you mentioned a challenge with lack of accountability. However, if we look at the humanitarian law violations or indeed human rights violations that were committed by human officers by mistake, by an honest mistake, we would also find that there is no criminal responsibility for those kinds of actions. And there are a lot of examples too, like for example, in one of the US operations in Afghanistan when there was a miscommunication error and the pilots bombed a hospital that belonged to Medicine Sans Frontières facility, and no one was held criminally responsible because it was an honest mistake. So maybe that's not such a problem, this lack of accountability, because every might be committed by an autonomous weapon system effectively be equal to a human honest mistake. Thank you.
Okay, so to answer your first question, I'll have to remember them in my head. To answer your first question, yes, we don't know what the technology is going to be in the later years, but I think that's why it's so urgent that we start working on policy now to set that precedent for the law moving forward. Because even if we know what we're doing now, it'll be easier to create more regulation moving forward than just having to start completely new. Second, you talked about are the countries using autonomous weapons now, are they violating law? I would say right now that autonomous weapons and autonomous weapon systems are kind of existing in a legal vacuum, and there's no true policy. They're a very new issue. They haven't been brought up by the UN until I believe 2013 was the earliest. And so there's no real policy. So as of right now, they aren't violating international law, but it'll be necessary for states to determine that later on. And with your last question, I'm forgetting your last question. Could you repeat that briefly?
Yeah, the accountability. Is it really a problem? If it can be equated to an honest human mistakes, which is not punishable either?
I think obviously we don't live in a perfect world. Every offense isn't prosecuted and brought to justice. But with here, it's the question of at least we have an enforcement process. If we can create an enforcement process for the law, at least it's there and applicable in some places. I mean, there's always going to be situations where things aren't prosecuted, but wouldn't you say it's better to at least have a system where, in the case of violation, people or states can be prosecuted instead of having absolutely no way of enforcement or prosecution?
No, I'm sorry, I can't agree with you on that because, first of all, when we're talking about honest human mistake, it's not a deficiency of the current system that it's not punishable because, well, in international criminal law and, well, in the national criminal law even, you need, well, some sort of mens rea to be held accountable. And if it is an honest mistake, and if the human who was operating, for example, a weapon could not have known that he or she were doing something wrong and were like about to commit a violation, then they couldn't be held accountable. And that would be true with autonomous weapons because an autonomous weapon cannot have the intent to violate international law or like any kind of law because it is programmed just the way like it should be programmed to avoid such violations. So it would be akin to human mistake, which is not punishable, not because of some omission of international regulation, but because of the inherent logic of responsibility, of criminal responsibility.
Well, yes, and that's why it's such an issue because they don't have that mens rea. They don't have that capability of intent. And that's also why I included the programmer as a possibility for prosecution because they're the one programming that autonomy. I mean, that's obviously going to be a difficulty, but I still argue that it's best to have a system in place for prosecution and a way to hold things to justice and hold these systems accountable rather than have it exist in a legal vacuum. I think that's very dangerous for conflict, having absolutely no regulation.
Okay, thank you, understood.
Thank you, Tamara. Thank you, Nicholas. We should proceed with the next report. The next report continues the topic of human rights, and the author describes the history of understanding the right to education, current understanding, and implementation of this right during the pandemic. Taibova Zarema, Rudan University, Faculty of Law, third-year student. Right to education in the light of sustainable development goals.
Thank you. Good afternoon, dear colleagues. I want to tell you about the right of the education in the light of sustainable development goals. And the first I would say the right to education is one of the natural, inalienable, and fundamental rights and freedoms of humans, which can be described as the right to empowerment. In 1945, the London Conference established the UNESCO, which has developed and adopted, among others, the Convention on Combating discrimination in education of 1960. Nevertheless, despite the progress made, especially in the developing countries, where the number of primary school-age children out of school has decreased by half from 2000 to 2015, access to education remained an area of unresolved challenges. They were reflected in the UNGA resolution, Transforming Our World, a Sustainable Development Agenda for 2030 of September 2015. The document reforms commitment to global partnership for development and establish basic principles of accountability for the implementation of the goals. The UN Sustainable Development Goals in the Russian Report of Human Development in the Russian Federation presented by the Analytical Center of the Government of the Russian Federation highlights SDG 4, quality education, is particularly relevant. The main tasks in the field of higher education are to improve its quality and meet the economic needs of the state. 96% of Russians have at least a complete secondary education, but Russia falls back behind 5 countries of the world in terms of share of higher education. Despite a number of positive changes in the education sector of the Russian Federation, the existence of some problems indicates decrease in the pace of further development of this area and the potential of the education system. In addition, the relevance of the implementation of the SDGs is reflected in the President's address to the Federal Assembly in 2018, as well as in the decree of the President of the Russian Federation of 7th May 2018, number 204. The May decree highlights priority areas, including the development of education. In particular, the Russian government has a responsibility to ensure the competitiveness of national education on the global stage and to occupy a top 10 position in global ranking in terms of the general education quality. These documents define objectives in the field of education corresponding to SDG 4. On 14 July 2020, at the UN headquarters, the Minister of Economic Development of the Russian Federation presented the first voluntary national review of the achievement of the Sustainable Development Goals prepared by the Analytical Center of the Government of Russia with active involvement of RUDN, or in English, PUR. This document was proposed to the attention of the high-level political forum on sustainable development under the auspices of ECOSOC and contained information on each task within the SDG number 4. For example, one of the tasks is to increase the number of scholarships to developing countries for higher education. This is task 4B. Assistance to foreign countries is provided in the form of scholarships quotas for secondary vocational and higher education in Russia. Achievement of SDG number 4 is of particular importance to states of the Middle East, where ordinarily not everyone has access to education. In particular, Kuwait has also made voluntary commitments to achieve the SDGs. To this end, the National Committee for Sustainable Development and the National Observatory for Sustainable Development were established. More than 13 national seminars were organized, attended by representatives of the governmental and private sectors. Kuwait's achievements on provision of free, equitable, and quality primary and secondary education for everyone are confirmed in its report to the UNCRC of 2018 and the Global Gender Gap Report of 2015. According to the latter, Kuwait ranks first in the Arab world in achieving gender equality in such indicators as women participation in the education level. Measures are also taken to overcome inequality among different categories of population, Kuwaiti, non-Kuwaiti, and Bedouins, including provision for each category of equal education attainment and curriculum, enrollment to same schools, classes, and activities. However, some Bedouin students couldn't receive scholarships and they lacked in identity documents. Moreover, only citizens or children born to a Kuwaiti mother have access to full compulsory education. As part of SDG 4.2, Kuwait considers inclusion of compulsory education in kindergartens and establishment of a working group to prepare a national framework for preschool children.
Sarema, 1 minute left.
Okay. To assess the achievement of a special progress index for SDGs, an index is developed which consists of net enrollment, literacy rate of 15 to 22 years old, and completion rate of secondary education. In terms of quality and inclusive education in Kuwait, the percentage of citizens with complete secondary education and literacy rate have increased. More states have announced the temporary closure of schools, affecting more than 91% of students worldwide because the COVID-19 pandemic caused a particularly negative impact on the achievement of the goals. By April 2020, around 1.6 billion children and youths were out of schools, and nearly 369 million children who received school meals were forced to look for other sources of daily food. In March 2020, UNESCO launched the COVID-19 Global Education Coalition, a multi-sector partnership between UN agencies, civil society, media, and IT to develop and implement innovative solutions aimed at futures covering questions of mobility and problem solutions. The UNICEF has also increased support to 145 low and middle income countries in developing rapid system-wide response plans, including alternative training programs and psychological support.
Zarema, could you please get to the conclusion because the time is up?
Okay, thank you for your attention, and I'm sorry for my pronunciation. It was my first conference presenting in English.
Thank you.
Thank you very much, Zarema. Our participants, do we have any questions for Zarema or comments? Okay, no questions.
There is a question from Yana Krylova.
Could please open the chat?
Yeah, thank you. I would like to thank the speaker for the topic she has been speaking about. So my question is, you've mentioned the fact that the COVID-19 has affected the process of education globally. So do you personally think that the fact that not each person has an access to technological equipment while switching for distance learning was the factor of depriving people of their right to education? Thank you.
Thank you for a question. It's really a big problem for the right of education, and exactly UNESCO Global Education Coalition try to I forgot the word. We solve this problem, yes.
Thank you.
Okay, thank you very much. We proceed with the next report. We have another representative of Russian People's Friendship University, who will present the topic pretty similar to Nicholas. So, Aloyev Kantemir, Rudian University, Faculty of Law, fourth-year student, autonomous lethal weapons in light of the principles of international humanitarian law. The floor is yours. Share your points of view.
Good afternoon, colleagues. Thank you. The topic of I have took is autonomous lethal weapons in the light of principles of international humanitarian law. And let me introduce you in the term of autonomous lethal weapon. It's weapon that is complex of weapons that includes a special system of algorithms that can independently and in real time determine the means of intelligence, control, delivery, and destruction for an attack without human intervention. Currently, I think the use of autonomous lethal weapon is one of the main problems facing states, international organizations, and society as a whole. And attempts by a number of states, for example, Russia, USA, United Kingdom, to recognize the use of these weapons as legitimate cause lively discussions. A number of international scientists, military and technical experts have already expressed their concerns about the future use of it. and they state that it would cause social, public, and political concerns.
Sorry, Kantemir, it seems that you have some problem with your microphone. Could you please?
Is it better?
Yeah, sure.
Okay, I continue. The main question remains whether autonomous lethal systems can be used for reasonable purposes to help individuals and society. Professor Blishenko considers the following to be among the basic principles of international humanitarian law. The first principle is principle of good faith and loyalty. And what does it mean? It means that these weapons should be based on the inadmissibility of the use of harsh and inhuman means of conducting armed struggle, restrictions on the choice of means and methods of war by belligerents. Scientists and experts note that responsibility for the illegal creation and use of algorithms for autonomous lethal weapons is considered in the context of criminal law. Why? Because artificial intelligence cannot be held responsibility for the consequences, of course. The second principle is the principle of humanity. In the context of this issue prohibits the use of killer machines, since robots do not have and do not have human qualities, including feelings of regret and compassion for the living during combat. The third principle is principle of protection of peaceful objects means and implies that the use of autonomous systems should be restricted strictly to military zones. The following lawmaking and adoption of international legal norms regarding the use of autonomous lethal weapons should be based not only on the basic principles of international law, but also on the institutional principles of international legal regulation of arms trafficking. And what concerns us, and especially me, that today there are no specific international legal act in the field of development and use of these autonomous lethal weapons. The complexity of implementing the convention provisions, taking into account the multi-vector interests of states, increases the role of soft law at the present stage. Despite its non-binding nature at a certain stage, it can provide intermediate regulation of a preparatory nature based on stable points of agreement on specific aspects. In other words, the long-standing norms of international humanitarian law governing the conduct of hostilities, in particular the principles of distinction of objects, proportionally, and the adoption of precautions in an attack applied to all new types of weapons and technical innovations in the field of warfare, including autonomous weapons systems. Moreover, any approach to rulemaking in the field of the use of autonomous technologies that pose a threat to our lives must ultimately rely on empirical scientific results comparing the advantages and disadvantages of a decision-making process by both humans and machines. If in future it turns out that machines are better in this aspect and less biased, that will be accepted that these autonomous lethal weapons can be used by society and be of great importance.
1 minute left, Kantemir.
As a conclusion, I would like to say that states must decide when the use of autonomous lethal weapons is unacceptable. We should also take into account the risk that this class of weapons may fall into the hands of terrorists. Deadly autonomous systems, known as killer robots, must remain under the control of individuals and organizations involved in their development, since the punishment and legal responsibility for violations of the principles and provisions of international humanitarian law cannot be assigned to the machine, as we said. Many politicians and scientists agree that states and international organizations should not allow the adoption of international legal acts aimed to recognizing the legality of the use and creating of autonomous lethal weapons. Thank you.
Thank you, Kantemir. Dear participants, do we have any questions for Kantemir? No questions. So, hi. We have a comment from Alexander Nikolaevich.
Oh, probably question. Thank you for your report. My question is about the key term, which is in the title of your report, International Humanitarian Law. You probably don't know. If you don't know, please tell me. If you know, please tell me. What do you think about the meaning of this term? According to Professor Ignatenko, it is one meaning. According to Professor Kolosov, it is another meaning. And the position of Professor Kolosov is closer to the position of the International Organization of the Red Cross. So my question is, what is your position about the meaning of this term, international humanitarian law?
Sorry, what term I should explain?
International humanitarian law.
As I understand it, it's a system of regulations between countries that states that joined it should accept it and follow strictly.
Well, thank you, Kantemir. We have one more question from one of our colleagues here in the conference room.
I would like to say thank you for your report. And you've mentioned that one of the criteria of autonomous lethal weapons is the protection of peaceful territories. But you also called them in your conclusion killer robots, and you said that the states decide if it is appropriate to use them. So isn't it more beneficial to just forbid to use them? Because, well, I think that this is a really very big risk that this is just inappropriate to do that. Well, to use them.
Kantemir.
Yes, as I said, states should take serious investigations with scientific methods of evaluating all of the risks, and only after it, the organizations should make a decision to use these technologies or not to use.
But what if they think they will decide to use it, and then there's going to be some mistake or something like that, and it will cause, massive or some negative results? Then what?
I think there should be some organization that will maintain this technique and that would take a responsibility of acts of these machines.
Well, yeah, I agree with that.
Thank you. No more questions. No questions in Zoom chat. So thank you again for your report. Let's move on to the next report. Zhukova Olga, Moscow University of the Ministry of Internal Affairs of Russia, to the issue of international cooperation to ensure and protect the rights of children during the COVID-19 pandemic. Please, Olga, the floor is yours.
Good evening, every professors, every students. I want to sorry for my English. It is worse than students in this perfect comprehension. Now we see the presentation and let's talk about the issues of international cooperation. At the present stage, the world community is facing a new, perilous and known threat. In 2020, the scale of pandemic has reached the level of global problem that poses the fear to the most of countries of the world. In connection with the COVID pandemic, states are introducing a number of measures aimed at limiting fundamental human rights and freedom in order to reduce the number of cases as well as the spread of coronavirus. However, the above message make people, in particular women and children, and most vulnerable at the present stage. Children can be exploited to violence, domestic and gender, and other forms, fall into the hands of the traffickers, or be exposed to sexual and other purposes. In addition to the above aspects, schools have been closed in many countries due to the COVID-19 pandemic. It shall be noted was a certain problematic and crisis period. Education institutions maintain a sense of stability and everyday routine in children. However, during the pandemic, due to the closure of school in some countries, students are forced to the street in order to find the food, which greatly increases the risk of being exploited or becoming a living commodity. Children from the region affected by armed conflicts, as well as refugees, migrants, and the children left without parents, care deserve special attention. It is previous to these categories of children what states need to pay special attention and introduce certain control measures to prevent children forced marriage, children getting into sexual or labor exploitation, or becoming victims of human trafficking. The special organization, the United Nations International Children's Emergency Fund, or just UNICEF, was founded in 1946 year after Second World War by General Assembly of United Nations. And UNICEF was introduced with the main function of providing assistance of children affected by armed conflict in various states. In addition, UNICEF is engaged to extend to development countries with the refugees study of medicine, food, equipment for schools, and for medicine. The international legal framework for cooperation between the states, international organization, or just subject of international law, ensure protect the rights of children is a number of international acts. In particular, in Declaration the Rights of the Child and the Convention the Rights of the Child are the most important, and there are some international documents in the soft law. An important act of internationally begin charter, in my opinion, and especially worth as a present stage, is the Palermo Protocol. After all, children are the most vulnerable due to the physical and mental ability to fall into service. During the COVID pandemic, UNICEF points out the economic damage caused by the pandemic and signified, and that some 17 million children may end up to extreme poverty, which you know above, inside the risk of falling into the hands of traffickers. UNICEF responds to the problem to mobilize recursos to stop a spread of COVID-19. In particular, the applied to Europe and Central Asia.
UNICEF cooperation with the government, United Nations organizations and bodies, as well as the National Law Enforcement Agency. This cooperation is expressed, first of all, in providing assistance of development countries with the purpose of personal product equipment. The organization joint points the mobile point of examining and accent to potential effect by COVID-19. In addition, UNICEF assisted National Ministry of Education to introduce distance learning in the various languages, including some languages in 16 countries. All the above measures, in my opinion, they are effective at helping children from low-income, famous and developing countries. In particular, there are some organizations who can responsible for ensuring they protect children's rights. In this international system for the product, the rights of child is military agreed. It consists of the international legal framework, manifest, and number of declaration, convention, and agreements, as well as the main institution function under the aspect of the United Nations organization and coordination, international cooperation in this aspect. States and international organizations are implementing actions to ensure and protect the rights of the child in order to form file of harmonious personality.
Olga, 1 minute left.
Thank you. During the COVID pandemic, states need to ensure, first of all, children's access to education in order to value children's right to education. Because children are the future of our planet, and education of children is the most important aspect in the international cooperation of subject of international law. Thank you for your attention. Sorry for my English. And I can answer all your questions.
Okay, thank you very much, Olga. Well, let us not embarrass Olga with your questions. I think it will be quite difficult for her to answer them, and proceed with the next report. The next topic is headlined, the next report is headlined, the legality of nuclear weapons under, under international law. The author will make an attempt to answer the question about the legal status and interpretation of the rules governing nuclear weapons. Please welcome our foreign participant, Kundrić Alexa from University of Belgrade, Faculty of Law, Master Studies. Alexa, the floor is yours.
Thank you very much. Greetings from Serbia. It is a great honor to speak at such an important conference. Nuclear weapons are the most dangerous of all the weapons manufactured in human history. The terrifying combination of their effects, including radiation, makes them the most destructive among the weapons of mass destruction. As such, it is an imperative for international law to regulate all their aspects, particularly their threat and use. However, even 75 years after the first and up to the present day the only one, uses of nuclear weapons in August 1945, the international law has no explicit norm, treaty or customary regarding nuclear weapons. Therefore, we must seek an answer to the question of legal status of nuclear weapons in legal interpretation of positive international law and international humanitarian law, IHL, in particular. And an inherent characteristic of legal interpretation in general is plurality of legal opinions. One of two dominant legal opinions concerning this issue is that nuclear weapons are not generally illegal under international law. On the contrary, the protagonists of this viewpoint argue that the threat or even the usage of nuclear weapons could be illegal under some circumstances. For example, it could be legal under the legal institute of self-defense or as a means of deterring another state's nuclear attack. Also, it is being said that since the international community did not condemn the use of nuclear weapons on Japan in 1945, an opinio juris was created that the nuclear weapons are legal to be used in certain situations. There has been also a reference to the rule of international law, which says that the states are free to do whatever they are not strictly forbidden from doing. One variant of this way of thinking is that the nuclear weapons are in no way different than other conventional weapons, and that they as such should be legally treated in the same way as all other weapons, which means that it would be legal to use them if such use is in accordance with general rules of IHL. For example, the principles of distinction, proportionality, neutrality, etc. The main advocates of this concept of possibility of legality of nuclear weapons are nuclear power states. On the other hand, there is an approach that regards the nuclear weapons as completely illegal under the international law. It seems that this approach is dominant in legal theory. This conception is also based on various arguments, which could generally be divided into two major groups. The core of the first group of the arguments is that the threat and use of nuclear weapons are contrary to the UN Charter, especially having in mind Article 2.4 of the Charter. The essence of second group of arguments is that the illegality of threat and use of nuclear weapons is deduced from the existing norms of international humanitarian law, such as the fundamental principles mentioned before, Martin's Clause, Geneva Gas Protocol of 1925, etc. It is true, as said above, that there is no explicit international law, legal norm regarding the legality of nuclear weapons. This stance was also asserted by the International Court of Justice in its advisory opinion concerning this issue from 1996. Even the Non-Proliferation Treaty from 1968, which is the most far-reaching international treaty on this matter, did not impose a general and explicit prohibition of nuclear weapons. However, these facts do not mean that at all that nuclear weapons could be legally used and that any state could legally threaten other states with their use. These weapons and the chain of destruction that they could create if used are so deeply in contradiction with the very foundations of human civilization, of which law is an integral part of, and that by no doubt they must be treated as absolutely illegal. Their effects, radiation in particular, are in their very nature completely opposed to the main principles of international humanitarian law. They just cannot be used discriminately and with distinction, and they cannot be used proportionally. Thus, the main goal of my report is to, after briefly explaining two main opposing theoretical, but at the same time practical approaches to this issue, making another attempt in favor of the opinion that the nuclear weapons in their very existence are contrary to the contemporary positive international law, and to put forward my main arguments regarding such stance. I think that the nuclear weapons indeed could never be used in accordance with the main principles of international humanitarian law, which are part of jus cogens of international law. I'm having in mind especially the collision of the principle of distinction and the effects of nuclear weapons, particularly radiation. By contrast, if we adopt the stance that the threat and use of nuclear weapons could be legal, we would create a legal ground for the eventual destruction of humanity, which would be a paradox. Law as an element of human practice would then make a justification for the ultimate destruction of human civilization. Thank you very much.
Thank you very much, Alexa, for your speech. Now, dear listeners and participants, would you like to ask any questions? Valeria Birukova, please.
Yeah, good evening. Thank you for your very interesting report. And my question is, do you think a total nuclear disarmament is possible, well, in the future, so that all the states would deny nuclear weapons and will destroy all of them and never have them again?
Thank you for the question. My report was based primarily on the analysis of current positive international law. And I emphasize that, as I think, under the current positive international law, IHL in particular, it is illegal to even possess nuclear weapons. The other question is this solution of international law possible or effective? Could it be enacted in practice? I think it is very hard to force. Nobody can force five strongest states in the world to completely disarm themselves. Maybe it could be possible to try to change the international law, or to try to work on this decisive work to persuade people that states should disarm themselves. But I think that it would be largely impossible under present circumstances. Thank you.
Thank you very much. Do we have any more questions? Okay, let's proceed to the next speaker.
There is one
Nikolai
more question, I would say.
Sorry?
Zoom. If we have enough time, there is one more question in Zoom.
Please, Alexander.
Okay, my question is, thank you for your report, of course. My question is, do you consider the legality and the current possession of nuclear weapons as a restraint factor which restrain us from the Third World War?
Well, some major states, the United States of America in particular, have developed this doctrine of deterrence. They argue that if a state possesses a nuclear weapon, then the other states won't attack them with nuclear weapons. But under this logic, why shouldn't we allow every state in the world to possess nuclear weapons and to deter all the other attacks on themselves? So I think this logic is not correct, and I think that it is some kind of a privilege for strong nations to possess those weapons. And so I think that it is like a false claim in order to pursue nuclear armaments policy.
Mm-hmm. I agree with your point of view.
Thank you.
Thank you very much. Well, so now let's proceed to the next speaker, Nikolai Voslata, Lomonosov Moscow State University, Law Faculty, third-year student. Borders of restrictions on human rights as a result of emergency measures during the outbreak of pandemic. Please, Voslata.
Good afternoon, dear colleagues. It is a great honor for me to present my work today here, and I would like to start. So, beyond a shadow of a doubt, the outbreak of the COVID pandemic has changed almost all spheres of the modern life, including public health and human rights law. According to the United Nations Charter, to the preamble, states must ensure that everyone's rights and freedoms are respected under their jurisdiction. But rapidly developing pandemics require governments to use their best endeavors to protect their populations by implementing the state of public health emergency and restricted some human rights. Many states have been restricting human rights, such as freedom to movement, right to private life, and so on during the COVID pandemic. And those actions of states have led to the problem of balancing between, on the one hand, states' obligations to respect human rights, and on the other hand, states' obligation to protect public health from the spread of the disease. Thus, the aim of my work was to examine firstly the existing borders of restrictions on political, social, and economic human rights and freedoms in order to protect public health. Then I would like to cover the ways of preventing damage to the health of the nation by passing discrimination of rights and freedoms of individuals. And finally, I would like to consider an analysis of the existing practice of states during the COVID pandemic, and provide maybe some general recommendations for states to ensure their right to public health without discriminations against individuals. First of all, it is highly important to define the right to health and states' obligation to respect it. So under the World Health Organization Constitution, health is a state of complete physical, mental, and social well-being, and not merely the absence of the disease or infirmity. Moreover, the WHO International Health Regulation and recommendations lay down that states ensuring the right to health must monitor the availability of sufficient health facilities, goods, and services for all without discrimination in physical and economic terms, including marginalized groups. Secondly, I would like to turn back to the existing documents that establish international standards for ensuring the right to health during the state of public health emergency. Those, through the analysis of the CCPR, CSCR, Saracusa Principles, and General Comments number 29 on Article 4 of the CCPR, WHO recommendations and the international health regulations, and some regional level covenants, emergency measures may be authorized in the interests of public health and must meet the criteria of legality, necessity, and proportionality. In addition, the state of emergency imposed must be temporary, and any restrictions on rights and freedoms must take into account the disproportionate consequences for certain categories of the population, especially marginalized groups. Thus, the existing limits are addressed some qualitative and quantitative criteria and seek to prevent the infringement of as many rights and freedoms as possible. Moreover, the enactment of a state of emergency in response to the pandemic should not be used as an obstacle to the expression of public opinion, restricting their right to freedom of peaceful assembly. And moreover, quarantine and curfews should not be used as grounds for persecution of individuals, groups, or minorities. It is also important to prevent the introduction of repressive actions under the pretext of protecting public health. And now let's look at existing examples of state restrictions on human rights and freedoms during the COVID pandemic. For example, in China, the authorities not only hid basic information about COVID from the public at first, but also downplayed this severity of the disease and deny the possibility of human-to-human transmission. Moreover, there have been cases of people being detained trying to talk about the epidemic on social networks. And the discussion of the virus itself was closed. All those examples significantly violated the right of Chinese citizens to reliable information and freedom of expression. The same situation of violation of human rights were in Thailand and Iran, where the authorities also used judicial pressure, initiated the population, health workers, and journalists for criticizing the latest state measures to combat the epidemic, corruption, and possible hiding of statistics. And in Europe, due to the increased number of cases, the measure imposed were stricter. For example, in France, a nighttime curfew was imposed several times, and no less serious rules and fines were introduced in Italy, where the freedom of movement or individuals was massively restricted. Hence, there are different approaches of countries to restricting human rights and freedoms. But the overall picture shows a state desire to protect the population from the spread of the virus. But while third world countries and developing countries sometimes seek to turn the pandemic to their advantage by implementing state plans, developed countries and focused as much as developed countries are focused as much as possible on ensuring the well-being of their population. And from existing examples, we can highlight some general recommendations for a state to ensure their right to public health without discrimination against individuals. First of all, states should develop strategies to mitigate the impact on all segments of the population. Moreover, struggle, stigmatization, and discrimination against minorities in the context of the pandemic.
Zlata, 1 minute left.
Thank you. Ensure the confidentiality of personal data of individuals and provide materials support to medium and small businesses. States must ensure that social workers are fairly compensated for work that is at risk to their health. And to conclude, all restrictions on human rights and freedoms, both at the national and international levels, are subject to verification, which guarantees their compliance with the established standards. That's all that I would like to tell you today. Thank you for your attention, and I'm ready to answer your questions.
Thank you very much, Zlata. Dear participants, do not hesitate to ask your questions, to give your comments. Do you have any? Yeah, Yana Krylova, please.
Yeah, thank you for your work. It was very interesting to hear the statistics. And you've mentioned the system of paying fines in different countries. I mean, in Italy, in France, and so on. But my question will be, do you think that checkup system, which was implemented, for example, in Russia, I mean, using electronic passes for going out of the home more than twice, and so as well blocking students' cards, I'm sure you're well of it. do you think all these factors were interfering in people's rights to move freely as well?
Thank you for your question. Yes, to my mind, this is a matter with both sides. On the one hand, we have, Russia Federation has no choice in these circumstances, because we would like to, country has to protect its citizens, first of all. But on the other hand, by providing such measures, check systems, a state has to provide its nationals with the protection of its data. Because as we know, in the modern world, hacking attacks are possible, and it is highly important to escape them.
Thank you.
Thank you very much. Dear participants, any more questions? Yeah, sure.
So you said that it is for the well-being of the citizens when the state puts these measures. But you've also said that that is anyway a violation of their rights. But is it even a violation? I mean, the main human right is to life and health, and if that's for the well-being of people, then I don't think that it should be considered as a violation or restriction or something like that.
Yes, thank you for the question. You've raised another interesting question, which I actually don't tackle in my work, namely the balancing between public rights and individual rights. As for the public rights, of course, we protect our nationals by implementing the public health emergency, by closing borders and restrictions to freedom of movement. But on the other hand, we restrict some individual rights of one particular citizen. And in this context, it's controversial. And as we may see from existing examples of states, states still have not decided how to deal and in these circumstances, how to survive. But as for now, I may provide and I may conclude that states have chosen the public interest.
Well, yeah, I agree with you in that point. But if you said that they haven't decided yet, then, well, what would you kind of say, recommend what they should decide? Because that is so controversial.
Yes, I understand the question. So the pandemic is 1 year. This year we've been closed. So I think that states. I just don't see the point of the question, because unfortunately I think that as we may see, the states do make some do implement some measures, and they actually may be useful because they were trying to prevent the spread of the virus.
Yeah, I agree that they are trying to prevent it. That's not exactly what I meant, but anyway, thank you.
Okay, thank you very much for your discussion. We appreciate your scientific enthusiasm, but we have to stick to the plan. So the next reports will be presented by Astapova Anastasia, МГИМО University, International Law, second year master students. Treaty on the Prohibition of Nuclear Weapons, Undermining Global Security. Please, Anastasia.
So it's nice to greet all my colleagues here. I'm moving on with the topic of nuclear weapons. My research is devoted to the issue of the Treaty on the Prohibition of Nuclear Weapons, which comes into force in January 2021, and which is, from legal point of view, is highly likely to contribute to further undermining global security. So, ever since the establishment of nuclear weapons, the United Nations have strived for its elimination, obviously. And international efforts towards peace and security were consolidated throughout the recent decades in various multilateral treaties, and most importantly, through the Treaty on the Non-Proliferation of Nuclear Weapons. So, the existing international nuclear non-proliferation and disarmament regime has two integral elements composing its basis. Well, the first, the legal element is the Non-Proliferation Treaty, which comprises three essential components: non-proliferation itself, disarmament, step-by-step disarmament, and peaceful use of nuclear energy. And the institutional element of this system is the International Atomic Energy Agency, which administers the system of the safeguards. So from the perspective of the Non-Proliferation Treaty, disarmament can be obtained only in good faith and under strict and effective international control. But the Treaty on the Prohibition of Nuclear Weapons, which, well, comes into force soon, unfortunately, yet in its preamble states that the world free from nuclear weapons can be achieved only provided that there is a legally binding prohibition of nuclear weapons. Thus, the Treaty on the Prohibition of Nuclear Weapons makes a cornerstone of the legal instrument stigmatizing nuclear weapons and obviously the states who possess nuclear weapons. Further, the Treaty on the Prohibition of Nuclear Weapons doesn't draw a distinction between nuclear weapon states and non-nuclear weapon states, which is actually a basic principle of the current regime. And the treaty also vests the International Atomic Energy Agency with the functions for which the agency is not actually authorized. So the agency is not authorized to conduct disarmament activities. So it is impossible to use the agency to verify the obligations of the states under the Treaty on the Prohibition of Nuclear Weapons. So from an institutional point of view, the Treaty on the Prohibition of Nuclear Weapons obviously lacks specifics. So the treaty doesn't apply any adequate mechanism for monitoring the implementation of its obligations, which is unacceptable because we're dealing with global security issues here. So the time frame for de facto disarmament is not set in the treaty, which is also seems a bit strange. Later on, the essence of the legally binding plan mentioned in the Article 4 is unclear. And there is also no answer to the question what institution shall implement this plan, approve it, or monitor its implementation. Then Article 4 of the treaty further implies the designation of a competent international authority to negotiate and verify elimination of nuclear programs. However, from the text of the treaty, it is again impossible to identify the organizational structure and status of this body, its authority, its power, its creation procedure. As I have already mentioned, the treaty lacks specifics in this. And finally, Article 8 of the treaty states that any issues with regard to the implementation of the treaty are resolved by the meeting of the states parties. Once again, the status and the scope of authority of this meeting are unclear, not specified in the treaty. Well, and excuse me. Yeah, thank you. So in order to discern practical inconsistencies, we should answer the question, in fact, why do the states need nuclear weapons? And the answer is very simple. The answer is for security reasons. However, the strategic and security interests of the 9 nuclear powers and their allies have not been taken into account by the authors of the Treaty on the Prohibition of Nuclear Weapons. Basically, the total ban on nuclear weapons is introduced by the states that do not possess such weapons. Ironic, isn't it? And so 5 official nuclear weapon states, Russia, United States, Great Britain, France, and China, have declared in their joint statement 2 years ago that the Treaty on the Prohibition of Nuclear Weapons ignores the international security context and regional challenges and does nothing to increase trust and transparency between states. So, to sum it up, stigmatizing nuclear weapons by introducing this new treaty is not an efficient mechanism for achieving the goal of disarmament. Why? Because the treaty ignores existing security realities and actually the fact that utility of nuclear weapons has not yet gone away. Fortunately, yes, but that's true. And if the former conclusion doesn't seem convincing enough, there is another one. The Treaty on the Prohibition of Nuclear Weapons clearly contradicts the Non-Proliferation Treaty. It creates, so to say, a new legal regime parallel to the existing one. And the situation of legal uncertainty, of legal ambiguity, is, well, actually a threat to global security. And from our point of view, that is too a high price for raising awareness of a problem of nuclear disarmament. So thank you. Yeah, we're open for the questions.
Thank you very much, Anastasia. Do we have any questions or commentaries, dear colleagues? Yeah, Dmitry.
The said treaty. Is there any statistics with you?
So as far as I remember, there are 54 ratifications. Well, and hence the treaty comes into force in January.
How many states are in the world?
Well, 193.
More than 200. So can we say that we can consider this treaty to be a universal one or not? How do you think? What's your opinion?
Well, according to the treaty itself, it comes into force and, in a sense, becomes universal, I suppose, when 50 states ratify it. But there is no hint on what states should ratify it. To my mind, since 5 nuclear weapon, well, official nuclear powers haven't even signed the treaty, it can't be named universal. It is mere declaration of an intention to, well, to get rid of nuclear weapons, but no more. And that's where is the contradiction itself. And yeah.
Thank you very much, dear participants. Any more comments? Colleagues in Zoom? Nothing in our chat, I suppose. Okay, thank you very much, Anastasia. Now I'd like to announce that we are going to have a short break, 10-minute break. Then all the participants who are here today with us in the conference room will take a picture after you, when you come back, and then we'll proceed with 3 more reports. Yeah.
Good morning, everybody. Can you hear me?
Hello, yes, we can hear
to
you.
greet you.
Oh, excellent. Greetings, everybody.
Excellent. И как модератор, может, дадите мне слово, я представлю его? Да? Okay, okay. We'll continue. Dear participants of the International Students Conference, it is my honor and pleasure to introduce you Professor Paul Berkman. It's really a distinguished, outstanding researcher, the coordinator of a number of international programs, research programs, and also professor of a number of universities. I was honored to be invited at the international conference in Cambridge in 2011, in my opinion. If not, Professor Berkman will correct me. And Professor Berkman was the president of this international conference. And I might say that from this time, we collaborated for a number of years. We have, as a result of our collaboration, we have a number of books, publications, and one of the probably most successful is Environmental Security in the Arctic Ocean, lots of downloads. And I might also say that it is probably a unique case when Tufts University and MGIMO University for a number of years had a joint course for master's degree students relating to combination of international law and science diplomacy. Arctic is a case law for this particular discipline. And what I learned from Professor Berkman is that to try to have a synergy approach when you are making research, that is, try to see not only legal rules which are applicable to this particular relations, but also issues of policy, issues of diplomacy, even data of natural sciences, which is really very interesting. This multidisciplinary approach for theoretical assessments is really his, so to say, his peculiarity in the research. Professor Berkman, will you kindly tell your introductory speech before the International Students Conference?
With pleasure, Alexander, with pleasure. Yes, it is an honor and truly a pleasure to collaborate with Professor Villigjanen. You are all fortunate indeed to have him as your professor. I have only a few minutes to share with you this morning, but would like to preface that comments that I would make are designed to encourage additional collaboration together. Professor Villigjanen and I are planning to continue the course on science diplomacy during the winter, spring of 2021 at MGIMO. And the comments are designed to introduce, in a sense, the discussion, recognizing that MGIMO students, many go into the Ministry for Foreign Affairs of Russia, and that MGIMO is a leading institution in Russia, in particular association with the Ministry of Foreign Affairs. So it is, in a sense, looking at a global scale, the consequences and the realities, the processes, the skills, the methods, the insights, the vision, all of it, in terms of how we collaborate as a globally interconnected civilization. International relations is a component of all of that discussion. So I see that I have capacity to share screen, so I will do so. Let me see if I can, let's see here. There it is. Okay. can everybody see my screen?
Yes.
Yes. Mm-hmm.
Oh, excellent. Very good. So, so this is, as I mentioned, the intention today is to introduce the course that Professor Vilikjanen and I have been developing for many years. There is a synergy between research, education, and leadership, all three of them. And in listening and thinking about the course and the relationship that Professor Vilikjanen and I have, and with great pleasure and honor, I encourage you to think about the synergy between research, education, and leadership, recognizing the discussion, the dialogue, the progress that has been made, is ongoing, and will continue with Professor Vilikjanen and myself. Great fortune. So the context in a basic sense involves international, interdisciplinary, and inclusive. I have been in 5 meetings hosted by Vladimir Putin since 2010, following the development of the NATO Advanced Research Workshop that Professor Vilikjanen mentioned, which was the first formal dialogue between NATO and Russia regarding security in the Arctic Ocean, the only dialogue to date even, that was convened by Professor Vilikjanen and myself, demonstrating that it is possible for individuals with vision and a sense of diplomacy can contribute in constructive ways to dialogues among allies and adversaries alike. This is a discussion that is current in the world today with the COVID-19 pandemic, where we have a common interest in survival at local to global levels. The solutions that are involved require concerted effort of humankind on a planetary scale. These are discussions, these are real discussions, they are urgent discussions. They require common interest building among allies and adversaries alike, as illustrated during the height of the Cold War, initially in Antarctica, where the United States and the Soviet Union cooperated to produce the first nuclear arms agreement in the world, which was the Antarctic Treaty. Lessons from that have emerged in the context of science diplomacy. And Professor Vilikjanen and I both, in that capacity, serve as science diplomats. So the dialogue that really began all of this was the first formal dialogue between NATO and Russia. And it is a demonstration of a dialogue among allies and adversaries alike. It was not initiated because Professor Vilikjanen and I were telling anybody what to do. It was because we facilitated the opportunity for discussion about basic questions. What are the questions of common concern? And those questions of common concern, that process, in a sense, underlies the essence of science diplomacy as an international, interdisciplinary, and inclusive, holistic process involving informed decision-making to balance national interests and common interests for the benefit of all on Earth across generations. I would introduce, in spirit of science diplomacy, as an option without advocacy, respecting each of you as decision makers, that you can use or ignore the option that science diplomacy is a path to promote cooperation and prevent conflict at all levels of jurisdiction, from national to subnational to international. So this is the training. This is the thinking in terms of the course that Professor Vilikjanen and I are continuing. This is the journey of the research that we've been involved with in terms of thinking on a planetary scale with lessons that can emerge from anywhere, in effect. But the lessons that we're working with predominantly are in the Arctic. There are fascinating and important lessons for humankind across generations. Recognizing that about 30% of the Earth falls within the boundaries of nations, and that the 70% beyond the boundaries of nations is collectively defined under international law as being beyond sovereign jurisdictions. International law is the fundamental framework, in a sense, that creates the stability and the lessons of international law, you have in your midst a world leader in terms of international law, Professor Biligjanen's insights and receptiveness and intuition, precision are important in terms of how we evolve as a globally interconnected civilization. So it is with honor to be able to share this with you. If we think in terms of international law, in particular, we look at the 20th century, not only can we think of ourselves as a globally interconnected civilization across the world on a spatial basis, we can also look at the interconnections on a temporal basis across time. If we look at the 20th century in particular, the 20th century is marked by animosity among nations during the first half, and during the second half with optimism and hope and inspiration with international law, the International Court, the United Nations, financial institutions with the International Monetary Fund and World Bank. These sources of stability have enabled the world to think in terms of connections. And over the last part of this 20th century, there was an exponential increase in the number of international treaties and conventions dealing with topics of the environment in specific. We think about specific agreements. The first one of the Convention on the High Seas was the very first international space identified in human history, beyond national jurisdictions, beyond sovereign jurisdictions. Second was the Antarctic Treaty, 1959. The third was the Treaty on Outer Space in 1967. The third area was the Deep Sea, with the Treaty on the Emplacement of Nuclear Weapons on the sea floor beyond sovereign jurisdictions, beyond the continental shelf. These contrasts between the first part of the 20th century and the second part of the 20th century, in a sense, reflects balance between national interests and common interests, which is the challenge we face forever in our world. And it is timely now in the context of our pandemic to think in terms of balancing national interests and common interests. And I would introduce for consideration that if science diplomacy is truly successful in terms of what it can accomplish for the benefit of all on earth across generations, and demonstration will be bringing United States, Russia, and China in alignment with the World Health Organization to solve the pandemic together on a planetary scale for the benefit of all on earth across generations. There are specific agreements that are involved in all of this that give lessons. One of them, the important one, is the law of the sea itself. And the UN Convention on the Law of the Sea from 1982 is instructive in terms of zones within the ocean that extend from nation state jurisdiction to international space, in a sense, again, across a continuum from national interests, common interests. And it's the precision, the granularity of being able to think across time and space that becomes the answers to how we evolve as a globally interconnected civilization. We can look at this in terms of space and time by looking at progress of human population size, or in the case of carbon dioxide in the atmosphere, trends, exponential trends. We can see the same type of patterns with our pandemic, just over shorter timescales. Climate, population size operate over decades to centuries. Our pandemic is operating with exponential change over months to years. The solutions are the same, bending the curve. We have a jurisdictional spectrum on Earth in terms of all of these discussions with the nation states at the center, and after the Second World War and First World War evolving into international. Now with mega cities and economies like California, fifth largest on Earth, we also have subnational. So there is a jurisdictional spectrum. And this has been part of the evolution of science diplomacy. I don't have time to go over all of these elements with you in terms of thinking, but just to say that it is an honor and a pleasure not only to be involved with research, but to be involved with education and leadership with Professor Biligjanen and MGIMO University. And in a sense, the challenge, the triangulation, the teaching that's involved is international, interdisciplinary, inclusive. It involves science and technology, it involves innovation, but ultimately it involves a triangulation, a synergy between education, research, and leadership. And just for background, for those of you that are interested in that, Professor Villigjan and I will have the opportunity to continue to interact with in the spring, this winter and the spring. The following is a compilation of previous courses that we've taught and the results, which are a set of declarations produced by student ambassadors in these discussions, effectively training skills with common interest building. The link below you, which I have sent to Professor Villigjanin and to Valeria, is available to you, and I look forward to future discussions. I have a moment or two, Professor Villigjanin, to answer any questions if there are any.
Thank you very much. Students, do you have any questions to Professor Bergman? Because he has another conference in a few minutes, but you have time a little bit, 1 minute or so.
I alerted them, I've got about 10 minutes, yes.
Okay, any questions?
Any questions? So,
perhaps our colleagues in Zoom, you can raise your hand and we'll give you.
The essence of all of the training of building common interests among allies and adversaries alike, the essence is the foundation itself. Foundation are questions. The questions of common concern provide guidance for allies and adversaries alike to address the methods to answer those questions. So questions are fundamental, and I encourage you and welcome your questions, please.
We have a question, Professor Bergman, from Nicolas Centeno from Geneva.
Okay. Hello, Nicolas.
Hello, Professor. Thank you for speaking. My question is, you're talking about like having the states, you mentioned United States, Russia, China coming together to solve the COVID pandemic. How do we combat states or leaders that seem to be ignoring certain scientific truths? There was the issue with, for example, in the United States, lots of politicians denying the realities of COVID. So how do we overcome, I guess, ignoring the science and the research in order to truly solve these international issues?
Excellent question. I've spent my whole life trying to figure that answer out. And it was only within, I would say, the last 5 years where the answers became more increasingly clear. The observation is that there is a continuum of urgencies. The continuum of urgencies is short-term, long-term. And that with that continuum of urgencies, we can characterize what an informed decision is, that an informed decision operates across a continuum of urgencies. As a consequence, we can also characterize when decisions are uninformed, only operating short-term or long-term without the reality between. And so the problem that we're facing today in the world is short-term thinking in terms of nationalism. Nationalism is short-term thinking. We live in a globally interconnected civilization. The challenge is to understand how to operate across time. That's our fundamental challenge as a globally interconnected civilization, is how to operate across time, short-term to long-term. The pandemic actually provides lessons, insights as to how to do that, in the sense that we recognize there will be an inflection point in the pandemic, either because we've all been infected, there's a significant number of us will not survive, or because we've figured out how to vaccinate the entire world, the entire human population. One way or the other, there will be an inflection point in the pandemic at some point with certainty. In contrast to world wars, where there is no known or certain inflection point. So in a sense, the inflection point is a source of hope. My responsibility in this is to offer hope and inspiration and guidance in terms of how we as a civilization, globally interconnected, operate together. So if we take the inflection point as a boundary. Short term is before the inflection point. Long term is after the inflection point. And so the challenge, in a sense, is calling out the leaders of the world who are only thinking short term. The poster child of an uninformed decision is the United States walking away from the World Health Organization in the middle of a global pandemic, casually during a political discussion about China, without even dignifying the circumstances of lives and livelihoods in the home nation. This is the problem. And we have collectively responsibility to position the discussion among allies and adversaries alike, to think across time, to think short term to long term, that the solutions are just like with World War II. During World War II, during the World War in 1944, there was a meeting in Bretton Woods thinking about the international monetary system, the World Bank predecessor. All of that evolved, in a sense, before the end of the World War. Same with the Charter of the United Nations and the Statute of the International Court of Justice. They were crafted before the end of World War II, which happened in August of 1945 with nuclear weapons in Japan. We have the same opportunity now to think before the inflection point, to set in motion the types of solutions that will operate in the world after the inflection point. And that type of thinking, that type of compassion, that type of inclusion is open for all of us to think about together. And in a sense, it's an idea. And the things that will work in the world, the things that are continuous through time, are not military forces. They're not great nations. They are ideas. That is the reason religion and science have persisted through millennia as systems of knowledge. Indigenous culture is the same. So in a sense, the challenge we face today, your question's a good one, an important one. Challenge we face today is to operate short-term to long-term, to think across a continuum of urgencies, from security to sustainability timescales.
Thank you, Professor Bergman, for your time and for your excellent, short, but really outstanding presentation today at the Students' Conference. I appreciate it. It's early in the morning in your country, I understand.
With pleasure at any time of the day, Alexander.
And bye now. Thank you very much once again.
Goodbye, everybody. Look forward to next discussions. Thank you, Professor Vilichanen.
Thank you, Paul.
Thank you.
Bye.
Goodbye.
Dear participants, now we shall proceed with our agenda. And the next report is devoted to evolution of grounds for the use of force and the process of formation of humanitarian intervention as an international custom. Pilavova Alexandra, Lomonosov Moscow State University, Faculty of Law, first year student. Please, Alexandra, the floor is yours.
Good evening. Will you show my presentation?
Yeah, sure. Shall we begin?
Yeah, and change the slide, please. The genocide in Rwanda, the Srebrenica massacre, the conflict in Kosovo raise the issue of the existence of the right to unilateral humanitarian intervention. International law is actively developing. And if in classical international law, the sovereignty of the state was a real border and could justify any internal events, the modern international law proclaims the principle of respect for human rights and the obligation of each state to protect these rights. Moreover, respect for human rights is viewed by many as an erga omnes obligation. which allows states to take certain measures to compel other states to fulfill their obligations. This approach, as interpreted by some researchers, also justified the possibility of armed intervention in a state that grossly violates human rights on its territory. There is a point of view that this is a custom which was formed in international law, and such protection can be carried out without obtaining the permission of the relevant UN bodies. This is due to the fact that UN Security Council is not always ready to make a decision on intervention quickly, as it was in Rwanda in 1994. There is also a threat of blocking resolution by permanent members of the UN Security Council, which in this case can be guided by only political motives. So, has the right to unilateral humanitarian intervention emerged as an international custom today? Please, can you change the slide? On this slide, we can see examples when states intervened in other states for humanitarian purposes and without the permission of UN Security Council. According to Article 38(1)(b) of the ICJ Statute, international custom consists of state practice and opinio juris. State practice can be expressed by physical actions. For example, the activities of ECOWAS on the territory of Liberia in 1990. So the Kosovo crisis in 1999 directly raised the question of the legitimacy of unilateral humanitarian intervention. The justification for the NATO's Operation Elite Force was motivated by humanitarian necessity. There are not only positive examples of humanitarian intervention that prevented gross and massive violations of human rights, but also tragic moments in the whole history when the intervention was not carried out and the actions of the UN Security Council were ineffective. For instance, the UN mission was unable to take any effective actions when in 1994, the Rwandan genocide claims the lives of about 800,000 people. This is an example of what the inaction of states and the politicization of the UN Security Council can lead to. The genocide in Rwanda became a lesson for the world community, after which Kofi Annan began to promote the concept of responsibility to protect, or R2P. Now, not all countries are ready to follow this concept, fearing that such an approach could become a pretext for violating national sovereignty and aggression. Can you change the slide? Thank you. Opinion juris can be expressed not only in direct recognition and support, but also in non-resistance, as it was in the situation in Kosovo or Iraq. So the UK stated about NATO's Operation Elite Force that military action could be taken in exceptional circumstances and to avoid a humanitarian disaster in accordance with international law. Belgium argued that such force was used exclusively for humanitarian purposes, and it was compatible with Article 2.4 of the UN Charter. In fact, NATO's intervention in Kosovo was approved by Bulgaria, Romania, Slovenia, Poland, and Czech Republic. The Kosovo intervention found the wide support among the UN member states. NATO's actions were nevertheless condemned by some states, including the permanent members of the UN Security Council. The right to intervene in another state can also be derived from the obligation to prevent and suppress acts of genocide and crimes against humanity. Back in 1951, the ICJ decided that the Genocide Convention was to become universal in its scope. The ICJ also indicated that the duty of states to prevent genocide extends to the duty of prevention at interstate level. This means that the suppression of genocide is an erga omnes, and states are obliged to prevent the commission of genocide on the territory of another state. It is worth noting that within the framework of the African Union, there is a mechanism of humanitarian intervention that doesn't imply the permission of the UN Security Council, but such use of force must be accompanied by regulatory principles. In 1974, the International Law Association formulated a list of conditions for the recognition of humanitarian intervention as legitimate. But such concept is not binding for members of international community. It's only a doctrine.
Alexandra, 1 minute left.
Thank you. Can you change the slide, please? Thus, today the right to unilateral humanitarian intervention doesn't exist as a custom. Moreover, humanitarian intervention conflict with existing norms and principles of international law. The international community is ambivalent about the concept due to the fact that unilateral humanitarian intervention can be used to justify the intervention of stronger states on the territory of weaker states. The lack of developed criteria under which the right to humanitarian intervention is possible only aggravated the problem and complicates its normative consolidation. In international law, it is necessary to make systemic improvements aimed at the full implementation of the principles of respect for human rights and the non-use of force in international relations, as well as depolitization of the main body responsible for maintaining peace and order, the UN Security Council. Thank you for your attention.
Thank you very much, Alexandra. Dear participants, do you have any questions or comments to the speaker? Alexandra, please.
Thank you for interesting and exciting report. And my question is, we know that the Security Council that decided about the intervention in the particular case. So maybe we should to reform the Security Council and this UN structure, and in this way, this leads us to reforming the Institute of Humanitarian Intervention in general. Maybe we should do it in this way.
To be honest, I didn't understand your question at all, but I just said that we must reform that UN Security Council structure needs to be reformated because of permanent members, which always, not always, but which sometimes use their right to veto, and it prevents to help, if it's necessary, help to some states to prevent genocide or violating of human rights. Maybe I didn't understand you at all.
You said that in the Rwanda case, yes, the Security Council, they didn't made efforts to prevent this genocide, to prevent this killings of innocent people. So, for example, if we have more members which can vote in the Security Council, maybe in this way we can prevent this genocide and further genocide, for example, in Srebrenica and other.
Yeah, I understand you. In the situation in Rwanda, UN Security Council tried to take some actions and sent a little mission to the Rwanda. And we know the story about Dollar's facts, when General Dollar sent the facts to the New York office that there are not enough people to prevent the genocide in Rwanda, but no one react on these facts. And we can understand that even when UN Security Council takes some actions, it can be not enough. These actions can be not enough for preventing some violations or genocide. And that's why we understand that maybe unilateral humanitarian intervention, for example, from NATO or other states, could be more effective in such situations.
Thank you very much, Alexandra. Let us proceed with the next speaker. Markova Anna Maria, МГИМО University, International Law, second-year student. Human rights protection in context of international legal struggle against crime. Anna Maria, the floor is yours.
Thank you. Greetings, dear colleagues. Human rights are fairly positioned as the main moral and intellectual value of the last 2 centuries, the most important idea of the international cooperation and world law and order today. Priority function of our world community and each state is providing a real possibility of implementation of the rights and freedoms of citizens, adjustment of the faultless mechanism capable to protect the personality from infringement of their rights, and to promote in necessary cases to their restoration. The international control of respect for human rights acts as essential for the realization of this function, and also as the catalyst of improvement of the domestic legislation and increase in efficiency of law enforcement practice of the national states according to the international principles and standards. However, despite significant progress, interstate cooperation in the sphere of human rights, it needs further improvement. Moreover, in the globalized world, there are calls and threats to human rights which were not existing earlier. It is possible to refer to the international and transnational crime, the menacing terrorism scales to them that dictates the practical need for studying of problems in the field of protection of human rights within international legal fight against crime and ways of their overcoming. The analysis of text of the international agreements on human rights, decisions of the European Court of Human Rights, reports of representatives of the United Nations on vectors development of the international cooperation in fight against crimes of the international character, allow to locate the following problems in the considered field and possible versions of their decisions. The lack of the universal, uniform concept of human rights complicating the international cooperation. However, this circumstance, in our opinion, should not be considered as a shortcoming. The modern international conflicts camouflaged under humanitarian intervention clearly show the double standards of international policy based on intrinsic contradictions in understanding of human rights by legal systems with different mental and cultural accessory. Therefore, the problem of a universalization of human rights at the present level of development of the international relations is potentially dangerous and can lead to negative consequences up to ideologically and politically motivated violence. In the doctrine, there is no universal definition of human rights violation. Having taken as a basis determination of human rights inherent from the birth and the measure of its freedom determined by the nature and dignity of the person, which is not dependent on the state, it is possible to come to a logical conclusion that any derogation, restriction, or deprivation of the person of their rights, irrespective of the subject of these actions, are human rights violation. From here, human rights violation is the special type of offenses which depend on the subject divided into two groups, violation from the state and violation from individuals. The policy of the state on development of effective policy for protection against threats of terrorism is often pursued with violation of fundamental human rights. The rights of citizens for access to information, freedom of the press, investment of intelligence agencies with the large powers providing access to bank accounts, listening of a telephone talk, reading of personal correspondence. Taking the measures counteracting terrorism, the states are obliged to be guided by the basic principles and rules of international law in the sphere of human rights. Inactivity of law enforcement officers and correctional facilities by human rights organizations and experts of the UN application of tortures, cruel, brutal, or degrading treatment and punishment is quite often noted. The solution of this problem seems in complex application of a number of measures. In the general increase in level of legal culture and sense of justice of law enforcement officers and correctional facilities for the purpose of education and professional ethics, and change of psychology of the attitude towards detainees and prisoners. The problem of restriction of human rights in the course of prevention of criminal activity and preference of interests of collective security dictates to the interest of a separate individual need of development of set of uniformly understood principles of restriction of the human rights, which are the invariable standard obligatory for execution by the states at application of similar response measures, compelled and exclusive on the contents. At the same time, certain human rights under no circumstances and conditions cannot be limited and broken. Thank you.
Thank you very much, Anna Maria. Dear participants, do we have any comments? Our colleagues in Zoom. Well, since there are no questions, we proceed to the last but not least report in our section. Anastasia Korzenyak, МГИМО University, International Law, first master's year. Legal regime of new types of weapons, methods, and means of warfare from a perspective of contemporary international law. Please, Anastasia.
I would like to introduce my report, my article about the legal regime of new types of weapons, methods, and means of warfare from the perspective of contemporary international law. Throughout history, and unfortunately at present time, wars and armed conflicts have been an unavoidable companion of humanity that entails death, suffering, violence, and disaster to a huge number of people. In the context of the current political situation, we observe the lowering of the threshold for the use of nuclear weapons, the withdrawal of the US from the INF Treaty, the treaty between the USSR and the United States of America on the elimination of the intermediate range and shorter range missiles, their refusal to ratify the Comprehensive Nuclear Test Ban Treaty, the collapse of the Iran nuclear deal, their refusal to negotiate in order to prevent the deployment of weapons in outer space and the creation of the US Space Force, and so on. Therefore, it's impossible to remove from the agenda the necessity of strict observance of the existing provisions of the international humanitarian law and the achievement of the balance between the inevitability of war and its humanity. Over the past decades, the world has accelerated the emergence of technologies that can give us unique capabilities to traditional weapons, that is artificial intelligence, machine learning, image recognition programs, algorithms for analyzing huge amounts of data, and so on. And these intelligence and learning machines and programs, they can even replace soldiers on the battlefield and, well, decide the outcome of armed conflicts instead of them. The most relevant issue in the context of accepted means and methods of warfare are lethal autonomous weapon systems. In 2016, a group of governmental experts was established to discuss it at the fifth review conference of the Convention on Certain Conventional Weapons. And this issue still remains extremely raw and ambiguous, and therefore it's quite reasonable, in my opinion, to be quite restrained from reaching any agreements due to the lack of prototypes of such systems, due to the difficulties of establishing definitions and drawing a clear watershed between military technologies and civilian technologies in the development of autonomous systems. At the same time, in my opinion, it's necessary to take appropriate measures in order to prevent such initiatives from harming scientific and technological progress in the field of information technology, artificial intelligence, and peaceful robotics. It must be, however, assumed that the existing provisions of the international humanitarian law are fully applicable to LAWS, and there is no indication that it is necessary to adapt the legal norms, the legal rules, and to take into account the so-called specifics of these weapon systems. International humanitarian law provides the necessary framework for the development and application of LAWS. This is, for example, Article 36 of the additional protocol to the Geneva Conventions. And in this regard, the development of any legally or even politically binding document is impractical and counterproductive, including the introduction of various moratoriums on the development of the use of technologies which have been developed to create such systems. And moreover, the discussions about the code of conduct on LAWS are also premature. Nevertheless, it is important to encourage the development of a common definition of LAWS and to maintain a dialogue on the characteristics of LAWS, their military application and human control. Otherwise, each state will have its own understanding of this weapon system and its own guidelines, which can lead to unpredictable consequences and misunderstandings that will result in a subjective division of such weapon systems into permissible and prohibited, good and bad. And that is actually the division based on the political references of a particular group of states. The position of the Russian Federation regarding new technologies in the field of creating such lethal autonomous weapon systems is that such potential systems can demonstrate greater efficiency than a human operator in solving tasks on the battlefield, reduce the likelihood of errors that may be caused by the mental or psychological state of the operator, his moral, religious, or ethical attitudes. And along with the destruction of military facilities and military objectives and the protection of the civil population, the potential areas of the use of such systems are the defense and protection of strategically appointed objects, for example, nuclear power plants, dams, bridges, as well as the elimination of terrorist groups, and the fight against mine hazards, and so on. And the subject of the discussion in the group of governmental experts on this topic should be limited to fully autonomous systems, to my mind, which are proposed to be understood as unmanned technical means that are not ammunition and are designed to perform military and supportive tasks without any operator involvement. It is in the context of legal regime of new types of weapons, means, and methods of warfare, it is logical to analyze Article 36 of the Additional Protocol 1 to the Geneva Conventions. And actually, this article neither contains any criteria for distinguishing new types of weapons from other types of weapons. I mean, those that have undergone multi-stage modernization. And this article doesn't provide any specific reporting format. As a result, the determination of new types of weapons, methods, and means of warfare remains at the discretion of the participating states. And these provisions of the article that relate to the research, to the RD, so research and development of new types of weapons are not subject to control and verification, since these stages of creating such weapon systems are strictly secret. And in turn, the acquisition and adoption of apparently, of presumably indiscriminate weapon system doesn't constitute a violation in itself, but a preparation for such a violation, or rather an activity of a controversial nature, since a violation involves precisely the use of these weapons by a prohibited method in an international armed conflict. So, to my mind, Article 36 of the Additional Protocol provides extremely limited opportunities to prevent the creation of new or high-tech upgraded weapons, and is actually quite advisory in nature. The dispositional structure of the Geneva Conventions and of the Additional Protocol created a situation where the law enforcement didn't develop under the Articles 85 and 88 of the Additional Protocol on suppression of violence, of violations, and on cooperation, whereas the institution of responsibility for serious violations is currently inactive. In other words, the system of enforcement of this multilateral treaty regime in case of violation of prohibitive provision remains problematic. Actually, due to the lack of the definition of lethal autonomous systems in international law, many analysts often rely on the functional concept of weapon systems autonomy that was put forward by the United States and by the International Committee of the Red Cross. It is based on a target selection cycle, but to my mind, such vague assumptions in the definitions already raise a number of questions. So how can the distinction between autonomous and highly automated weapons be legally defined, or how can automatic execution of functions be distinguished from the artificial intelligence? Which of these are clearly defined and predictable algorithms, and which include independent decision-making about carrying out a fire attack? And can we say that the algorithm of machine behavior, which was laid down by the developer of this program, means human control or not? So the proposed definitions, includes already existing military air defense system, for example, the Patriot used by the Bundeswehr of Germany, or systems of suppressing enemy radar stations, for example, the Israeli Harpy. So some hypersonic and space vehicles which are being developed today may potentially belong to such lethal autonomous weapon systems that is some time later, in the absence of clear definitions, but only vague and unnecessarily broad concepts, most weapons may fall under the definition of such LAWS. So it is necessary to pay attention to the following key aspects of the problem that the international humanitarian law describes. In detail, the rules of warfare and all military personnel are required to strictly comply with these rules and principles, and that issues of secrecy and national security will always dominate for each state. So an effective control of weapon systems, software of the armies of various countries in the world is impossible for both political and technical reasons. Additionally, you need professional expertise in order to verify and identify LAWS. Meanwhile, the use of autonomous weapons can be hidden or even classified. So the conclusions, of course, the codification and progressive development of international humanitarian law is obvious, and is obvious the significant contribution of the states to this process. But despite its relevance, the problem of lethal autonomous weapon systems remains extremely ambiguous. It is necessary, in my opinion, to assume that existing provisions of international humanitarian law are fully applicable to such systems, and there is no indication that it's necessary to adapt the legal rules to the specifics of such systems. And to my mind, the issue rather concerns the effective enforcement and implementation of international humanitarian law rules and principles at the national level, where an effective enforcement and control mechanism is possible, and the political will on the subject of the states themselves. Well, Article 36 provides really extremely limited opportunities to prevent the creation of such weapon systems, and we shouldn't cast aside issues of security, issues of national security and secrecy when a ban on lethal autonomous weapon systems actually will mean a ban on software, and therefore it is apparent that no state will allow to control its electronic equipment on the grounds of national security. Thank you very much for your attention. I'm ready to answer your questions.
Thank you, Anastasia, for your report. Certainly, there are going to be some questions from our participants and listeners, perhaps commentaries. Andrei Yermakov, please.
Yes, hello everyone. Thank you for your presentation. My name is Andrei Yermakov. I'm a student of МГИМО University. I have the following question. What is the perspective of the Arms Trade Treaty? Do you see the Arms Trade Treaty, the one that was made up by the UN in 2013, do you see it as being a significant player in limiting the arms export around the world and limiting arms in general?
Could you please repeat the name of the treaty?
Yes, can you hear me now?
Well, I think that I would like to do some further research on this topic. At the moment, I can't exactly say what is the perspective of this treaty and how it will regulate the legal regime of such weapons. So that's it.
All right, thank you for your answer.
Any more questions, dear participants? Oh, we have a commentary from Alexander Nikolaevich.
Yes, thank you for your report and presentation. It's really very, very important issue, and I would like to draw your attention to the dissertation in МГИМО University by Ivan Serov. The scientific supervisor was Professor Maleev, and he, in his dissertation and in his publications, by the way, he has made accent on these universal, regional, and bilateral arrangements regarding the exchange of new weapons and old weapons, and tried to say that, of course, we can see that there is a sort of fragmentation of applicable international law in this particular field. On the other hand, probably his good observation is that it is within the competence of sovereign states to conclude international treaties regarding trade of weapons, regarding transboundary movement of weapons, whether they are old or whether they are new. So my suggestion is that probably you might look through his publications, Ivan Serov, so that your research might be a little bit even more mature. It is good, very good right now, but probably it might really benefit from these publications, okay?
Thank you very much. I think that this dissertation and these publications are devoted to the trade of weapons. Am I right? Not on the trade. Mm-hmm. Thank you very much. Yeah. All right. Thank you. Thank you.
Thank you very much. So since there are no more questions, as I can see from our chat in Zoom, I'd like to thank all of you who joined us today, who participated offline and online. We appreciate your discussion, the seed of which originated during the first day of the work of this section. We have quite a weighty agenda on the second day of the section. So we urge every one of you to join us tomorrow. So that's at 15:30. Yeah, 15:30. So thank you once again. That's all for today. See you tomorrow. Bye. Goodbye.
Thank you. Thank you. Goodbye.
Thank you. Goodbye.
Thank you. Bye.
Thank you. Goodbye.
Thank you. Goodbye.
Thank you and bye.
Thank you very much, organization for and participation for such amazing conference. It was very interesting to listen all speeches.